the petitioner Asabuddin is allowed to be released on bail of rupees 50,000 with two sureties of like amount to the satisfaction of learned Special Judge Karimganj with certain conditions.
This Lordship, Lordship, I want to mention item number 5.
Yes.
Lordship, I pray that this matter may be listed after 3 weeks, Your Lordship. Yes, 5. To obtain the necessary instruction, Your Lordship.
First Lordship, this is a condemned matter. The order was passed on 19/5/2022, where this Honorable Court issued direction to pay the minimum pay scale to the petitioner, who is serving for more than 29 years on fixed fee. Now it's more than a year. The authorities are sitting over the matter.
Lordship, the matter, the government, they have given the approval to file an SLP in a similar case before the Supreme Court. So the Standing Council of Nagaland is taking steps. So Your Lordship, I may be allowed some time to obtain the instructions, Your Lordship.
And that case, Lordship, for submission may be reported.
Yes, Your Lordship.
Heard Ms. V. Sukre, learned Additional Advocate General, Nagaland. Also heard Mr. Wati Zamir, learned Counsel for the petitioner. Learned Additional Advocate General has sought for some time for seeking necessary instruction in this regard in view of the fact that government is contemplating filing of an SLP against the order in connection with which the instant contempt case has been filed. Stop. Learned Counsel for the petitioner has, on the other hand, submitted that this matter is pending since
Last year,
2022, and the petitioner has served for a period of 29 years. Stop. Considering the submissions made by learned counsel for both sides, the prayer of learned Additional Advocate General is allowed. Let this case be fixed after a period of 3 weeks.
Much better. Lordship, again, I want to mention item number 23. Your Lordship, here in the course list, it has been tagged along with item number 22. But Your Lordship, this item COP does not arise out of item number 22.
Okay.
And on, Lordship, on 4th of August 2022, this court has segregated the COP from this case. Because the present COP is arise out of WPC number 146 of 2019, Your Lordship. So, Your Lordship, here in the COP, the matter is now before the Cabinet for its approval. So, Lordship, can you grant 4 weeks' time, Your Lordship?
I'm appearing on behalf of the petitioner's counsel since he's out of station.
Heard Ms. V. Sukre, learned counsel for the heard Ms. V. Sukre, learned Additional Advocate General, Nagaland. Also heard Ms. R. Atsula. You are Miss? Miss?
Anand Longcha.
Alan Longchar, who is submitting on behalf of Ms. Supamwati Waling, learned counsel for the petitioner. It is submitted by learned Additional Advocate General that the present CO contempt petition has been wrongly tagged with WPC number 19/22, whereas this matter is related to WPC number 148/19.
146.
146/19. Hence, this is with item number 24,
22.
22 and
Yes.
23.
22 and 23. What is your prayer?
So, Your Lordship, my prayer is that on the last occasion, that is on 4th August 2022, this court has segregated the present contempt from this case.
It is also submitted that on by order dated 4/8/2022,
22.
the W- the pres- the WPC number item number 23 is WPC
146 of 2019.
146 of 2019
Yes.
was segregated
Yes,
from the present contempt petition.
Yes.
However, registry has again listed the same
Yes.
stop. In view of the order passed on 4/8/22, let this matter be
Lordship,
listed
this
after
4 weeks because
4 weeks.
the matter is now before the cabinet for its approval.
It is also submitted by learned counsel for learned additional public prosecutor that otherwise the matter government is processing the matter and it is
Yes.
pending for cabinet approval.
Yes, Lordship.
Stop. In view of the submissions made by learned additional advocate general, let this matter be listed again after
4 weeks.
4 weeks.
Much obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 18. Lordship, my senior is in bereavement, so can you list this matter after 4 weeks?
Heard Miss
Clear.
Kriekule, learned, who prays for an adjournment on the ground of personal difficulties of her senior. Also heard Mr. N. Angami, learned senior government advocate, who does not oppose the said prayer. Hence, the prayer is allowed. Let this matter be accordingly listed after
4 weeks.
4 weeks.
May I please, my lord? Lordship, the item number 22. Lordship, this matter is actually handled by my colleague S. Mere. Your Lordship, she has some personal difficulties today. If this matter can be listed after 2 weeks, my lord.
Heard Mr. N. Angami, learned senior government advocate, who prays for an adjournment on the ground that the present case is dealt with by another government advocate,
S. Mere,
namely S. Mary,
Lordship.
and prays for, stop. Learned counsel for the petitioner does not object to the said prayer. Hence, let this case be listed again after
2 weeks, my lord.
2 weeks.
Lordship, I would also like to mention item number 10, Your Lordship, on behalf of my colleague S. Mary, Your Lordship. I'm told that she is yet to file her counter affidavit. So if this matter can be listed after 3 weeks, my lord.
Heard Mr. N. Angami, learned senior government advocate, who submits on behalf of Ms. S. Mere, learned counsel for the state respondent, and prays for 3 weeks' time for filing counter affidavit in this case. Learned Mr.
Benison B. Shoaib.
Benisun V. Shoe, learned counsel for the petitioner, does not opposes the prayer. Hence, the prayer is allowed. Let this matter be listed after 3 weeks.
2 weeks. I have a similar prayer for item number 2, my lord. Item number 2, Your Lordship, on behalf of S. Mary, my lord.
Your Lordship, I have objection because there are some important issues to be discussed in this matter. So let the item be called out.
Let it be called.
Lordship, I'm told that there is a writ appeal, 35 of 2022, pending before the division bench of this court.
Your Lordship, then Your Lordship may have a look at the last order dated 24/7/2023.
It is item number 2.
Direction was given by this honorable court for a learned government advocate to bring instructions, Your Lordship.
In that case, Your Lordship, let it be passed off for a day, Your Lordship. The fact is, Your Lordship, my friend S. Mary,
She handles.
Your Lordship, her father-in-law has been admitted in ICU. There is a reason why she could not attend today, Your Lordship. However, if my learned friend has got objection, let it be passed over for a day, Your Lordship.
Yes, what is your submission? On the ground of ailment,
Your Lordship. Genuine difficulties, Your Lordship.
yes. Or let it be called for.
Pass over for a day, Your Lordship.
What is your response to her prayer?
Your Lordship, I
His
believe
prayer.
it would be better if the item is called out and necessary orders are passed.
Lordship, since we don't have the brief to argue the matter, Lordship, it will be one-sided argument.
No, you can make same prayer while the matter is called up. Instead of mentioning, let me also go through the file. Your prayer may be allowed also, but let it be called because your item number is item number 2.
Yes, my Lord.
You need not to wait long.
No, waiting part, Your Lordship, I don't have any objection. However, Lordship, since the counsel who is appearing, who is having the brief, Your Lordship, is having difficulties today, if it is possible for tomorrow, Your Lordship, just a day,
Response? Are you conceding or
just one day, Your Lordship, just for today.
heard Mr. N. Angami, London Senior Government Counsel, who submits that this case is dealt with by Miss
Yes, Mayor.
S. Mere, London
Senior Government.
Senior Government
Lordship.
Counsel, and whose father-in-law is ailing and has been admitted in ICU.
Lordship.
And on that ground, Learned Counsel for the Learned Senior Government Advocate prays for an adjournment for a day only.
Lordship.
Though Miss
Vitere.
V. There opposed the prayer for adjournment, vehemently opposed the prayer for adjournment. However, considering the grounds mentioned by Learned Senior Government Advocate for the adjournment, this instant case is adjourned for today. Let it be listed again for admission on 3rd of August 2023, that is tomorrow.
I'm deeply obliged, my Lord.
May I please, Your Lordship? Lordship, I beg to mention item number 15. Lordship, all the parties have been represented. SCR has been awaited. So once the SCR has been received, the matter may be listed for hearing.
Heard Ms. Tuyek Rulu, Learned Counsel for the appellant. Also heard Mr.
Lordship, for
Foseko Forte
1 to 5.
appearing for respondent number 5.
1 to 5.
Respondent number 5.
1 to 5.
1 to 5.
Lordship, I'm appearing on behalf of respondent number 6.
And Mr.
I'm on behalf of
Your name?
Nuksung Tila, counsel for respondent number 6.
Nuksung Tila, counsel for respondent number 6. It is submitted at bar that the LCR which was called for has not yet arrived, and hence the matter may be adjourned for today. Let the reminder be issued for the LCR again, and the matter be fixed after 4 weeks. After 4 weeks.
Lordship.
Yes.
Obliged.
Please, Your Lordship, I beg to mention hearing item number 33. On behalf of my colleague Inauli, let the matter be fixed on 10th of August, that is on Thursday.
Yes.
Heard Miss AIME
On behalf of Inauli.
on behalf of
Inaholi.
On behalf of Ms.
Inaholi.
Inaoli, learned counsel for the
State.
state respondent. Also, who prays for listing this matter on
10th of August.
10th of August. Also heard Mr. Wati Zamir, learned counsel for the petitioner, who does not have an objection to the prayer made by learned counsel for the state respondent. Hence, the prayer is allowed. Let this matter be fixed for hearing on 10th of August accordingly.
Your Lordship, I beg to mention item number 24 to 32, hearing item number 24 to 32. On behalf of Inaholi, let the matter come up after 2 weeks, Your Lordship.
This is short matter and the counsel for respondent, he has been seeking adjournment after adjournment. So
On what ground you are seeking
Your
adjournment?
Lordship, she's indisposed today, so Your Lordship.
next week,
Okay. Heard Miss AIME, London Government Council, who submits on behalf of Miss Inawali and prays for an adjournment on
After 2
the,
weeks.
for 2 weeks on the ground of ailment of learned senior government council. Miss Inawali is,
She's indisposed, Your Lordship.
yes, on the ground of indisposition of Miss Inawali. Also heard Mr. Isinlo, learned counsel for the petitioner, who submits that the state respondent is repeatedly taking adjournments in this matter, and the matter is of year 2022. However, considering the grounds mentioned by learned government council, this prayer is adjourned for a week. Let this matter be listed after a week.
publish.
May I please, Your Lordship? Lordship, I beg to mention item number 11 and 12. I'm standing on behalf of my senior Tombo Poner. Lordship, since the petitioner has approached the Supreme Court, if this matter may be kept pending till that matter is disposed.
Supreme Court in this matter.
Yes, sir. Yes, Lordship.
No, I have not understood. This is writ petition.
Yes.
With regard to this writ petition, you have approached Supreme Court.
No, Your Lordship, against the judgment passed by the learned single bench, the state has preferred appeal, Your Lordship.
State has preferred an
Appeal.
Okay.
Appeal was allowed. Appeal is allowed by the division bench of this honorable court.
Against that,
They are saying against that they have preferred
Okay.
SOP before the Supreme Court.
okay.
If I can give the number, Your Lordship.
Heard Miss
Sinla.
Asenla, learned counsel for the petitioner, who submits that the petitioners, you have already preferred an appeal, SLP.
Yes, Lordship. But kindly grant us 3 weeks time to obtain the SLB number.
Lordship.
Okay, have preferred an SLP before Honorable Apex Court in this matter and prays for 3 weeks' time for seeking necessary instructions. Also heard Mr. N. Angami, learned senior government advocate. Stop. In view of submission made by learned counsel for the petitioner, let this matter be listed after 3 weeks.
Lordship. Obliged.
Yes, Lordship, I beg to mention hearing item number 20. Your Lordship, my senior is indisposed, so I pray this matter may come up on 17th of August.
Heard Miss
Wickets or no?
VK, write her name, who submits that her senior Mr. A. Zimomi,
Yes, Your Lordship.
A. Zimomi is indisposed and prays for an adjournment on that ground. Also heard Mr. K.V. Angami, learned government counsel, learned senior government counsel, who does not oppose the said prayer. Hence, let this matter be listed after.
On 17th of August.
Hence, let this matter be listed on 17th of August accordingly.
Lordship.
Lordship, I beg to mention item number 19, Lordship. Lordship, may it be listed after 3 weeks. I have taken the consent of the other party, Lordship.
Heard Mr. K.V. Angami, learned senior government advocate, who prays for an adjournment for 3 weeks. He also submits that he has obtained the consent of learned counsel for the petitioner. Considering the submissions made by senior government advocate, the prayer is allowed. Let this matter be listed after 3 weeks.
Lordship. Lordship, item number 14, Lordship. After 3 weeks, Lordship.
You have taken consent.
No, Lordship, I could not locate the learned counsel for the again, Lordship.
You are representing state respondent.
Lordship,
No?
Lordship.
You have to inform him. Who is the counsel?
Here, Mr. Sapu is indicated, Lordship, but I could not. Actually, I don't know the learned counsel, so I could not contact him.
Because he may appear later on, and later on he may object to. Or let this matter be called.
Okay.
Called when, then we will consider your prayer.
Lordship, Lordship.
May it please your lordship, I beg to mention here in item number 21. I'm sending on behalf of my senior Joshua, since he could not appear today as he is out of session due to some emergency. If your lordship may kindly fix this matter after 2 weeks for
Heard Mr.
KV,
KV,
lordship.
who submits that his senior, Mr. Joshua Sheki, is out of station and on that ground prays for an adjournment. Also heard Miss AIME, learned government council representing the state respondent, who does not oppose the said prayer. Hence, the prayer is allowed. Let this matter be listed after 2 weeks.
Yes, lordship.
Please, your lordship. Lordship, I beg to mention item number 8. Lordship, may you kindly grant us 3 weeks' time to file my affidavit in reply.
You are Mr.
V. Koza for the petitioners.
Learned Mr. V. Koza, learned counsel for the petitioner, prays for 3 weeks' time for filing affidavit in reply.
For the respondents, private respondents.
Also heard Miss
Kids,
T. Skuru K,
kids, yes.
who does not oppose the said prayer. Miss AIME appears for the state respondent, who submits that state has already filed the affidavit in opposition. Considering the submission of learned counsel for the petitioner, let this matter be listed after 3 weeks. In the meanwhile, the petitioner may file affidavit in reply.
Much obliged.
Your Lordship, item number 16. Your Lordship, today only I filed Wakalatnama on behalf of respondent number 1 to 5. So, I need 2 weeks time to file my affidavit.
Heard Mr.
YP Gupta.
YP Gupta, who appears for
railway, respondent number 1 to 5.
Who appears for the respondent number 1 to 5 and submits that he has filed his Wakalatnama today itself and needs some time for seeking necessary instruction.
Lordship.
Also heard Miss
Lucino, lordship.
Lucino, learned counsel for the
Petitioner,
petitioner, who does not object to this said prayer.
lordship. Now all the respondents have appeared, so notice is complete now, lordship.
since it's listed in the orders. So.
She also submits that as all the respondents have appeared, you have taken steps for issuance.
Yes, Lordship. 1 to 5, Mr. YP Gupta is appearing, and for 6 to 7, Mr. Thiba is appearing for the state, Lordship. So all the respondents have appeared.
Okay. All the respondents have appeared. Considering the prayer made by learned Mr. YP Gupta, let this matter be listed after
3 weeks, madam.
3 weeks.
Lordship, there's an interim here.
The interim order shall continue till next date.
Obliged.
Obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 6 and 7 on behalf of Matai. Lordship, I was instructed to withdraw the case since there is some important documents which has not been annexed. So Lordship may kindly allow liberty to file a fresh one.
Heard Mr.
R. Semi, Lordship.
R.
Semi.
Who submits on behalf of Mr. M. Athai, learned counsel for the writ petitioner, and prays for allowing the petitioner to withdraw the instant writ petitions with liberty to file afresh on the ground that some technical defect is there which needs rectification. Ms. A. Aimi, learned government counsel, does not oppose the said prayer, hence the prayer is allowed. This writ petition is dismissed on withdrawal with the leave as prayed for.
For admission, item number 1.
My lord, the things have been completed so that let the matter be admitted, my lord.
Heard Mr. Imti Longchar, learned counsel for the petitioner, also heard Mr. Yangarwati, learned central government standing counsel. It is submitted at bar that pleadings are in this case is completed and matter is ready for hearing. Hence, this case is admitted for hearing.
My lord.
Let this matter be listed after 4 weeks in hearing column. No, not 4 weeks, in regular course. In usual course, in hearing column.
Much obliged.
For admission, item number 3.
May I please, Lordship? Lordship, kindly grant me 2 weeks' time to file my reply affidavit to the affidavit in opposition filed by the government.
Heard Mr. Moa Zamir.
Malhekuni,
Oh, sorry.
on behalf of my senior Mohan.
Heard Mr.
Malhekuni,
Mane Konyak, who submits on behalf of his senior Mr. Moa Zamir and prays for 3 weeks' time for filing affidavit in reply to the affidavit in opposition filed by state respondent. Also heard Ms. A. Aimi, learned government counsel, who does not oppose to the said prayer. Hence, the prayer is allowed. Let this matter be again listed after 3 weeks.
For admission, item number 4.
May I please, Lordship? Lordship, here I am for the respondent number 2, the Chief Engineer R&D Lordship. Lordship, on the last occasion, we have filed an affidavit that the matter that we have complied with the court order dated 14/12/2021, Lordship, and we have forwarded the matter to the government, to the Secretary to the Government of Nagaland, Department of Works and Housing, Lordship. And now the matter is before the PNR Department, Lordship. So we have already complied with the court's order dated 14/12/2021, Lordship, as directed by this honorable court. So this contempt petition may be closed, Lordship.
Yes, Ms. There.
Yes, Your Lordship.
What's your, sir?
With regard to the affidavit in the position that was filed by the state respondents, Your Lordship, they're saying that the competent authority for allotment of PIMS code is the PNR department, Your Lordship. Now it appears that they are shifting responsibility to one after another, Your Lordship. This honorable court has given a direction to respondent number 3, 4, and 5 in the writ petition, Your Lordship. That is the engineer-in-chief, chief engineer, and the executive engineer, Your Lordship, for disposal of the representation of the writ petitioner, Your Lordship.
What was the matter?
Lordship, the petitioner has filed the writ petition for disposal of his representation, and his representation was for release of his salary, Your Lordship.
Okay.
His salary.
In which department petitioner works?
Portability.
Okay. Thereafter, the writ petition was disposed of with a direction that 3, 4, and 5 will dispose of your representation.
Yes, Your Lordship.
Now, for 3, 4, and 5, Mr. Zimomi,
Lordship, I'm for the respondent number 2. Lordship may kindly come to the order 14/12/2021, page annexure 1. Annexure 1, page 9, Lordship. Page 9. Second paragraph, Lordship. Contempt petition. Of the contempt petition
just
filed by the petitioner.
page 9.
Page 9. Lordship.
Yes.
Lordship has got it. Lordship, the third relevant portion, third paragraph. May I read, Lordship?
Yes.
Being aggrieved by the non-payment of salary, the petitioner has filed the representation dated 18/11/2021 to the engineer-in-chief PWD Nagaland Kohima. Next page. Today, when the matter is called up, it is submitted by the learned counsel for the petitioner that the purpose of the writ petition will be served if a direction is issued to the respondent number 3, 4, and 5 to dispose of the representation dated 18/11/2021 submitted by the petitioner. MS so-and-so has no objection to the prayer for the disposal of the representation. In view of the submission made by the parties, the respondent number 3, 4, and 5 are directed to dispose of the representation dated 18/11/2021 submitted by the petitioner by a speaking order within a period of 2 months from the date of receipt of a copy of this order. Any decision taken by the respondent authorities shall be duly intimated to the petitioner. With this observation, this petition is disposed of. Lordship, as directed by this honorable court on 14/12/2021, Lordship, we have filed an affidavit in compliance to the affidavit. We have filed affidavit on the month of April, Lordship. If Lordship may kindly come to the affidavit in opposition filed by respondent number.
Who are 3, 4, and 5?
Respondent
In the writ petition, who were respondent number 3, 4, and 5?
Respondent number 4 is the Chief Engineer R&B PWD. And respondent number 5 is the Executive Engineer PWD R&B, Lordship.
Present condemnant number 1 and 2.
Lordship.
And
So accordingly, Lordship, respondent number 2, the Chief Engineer R&B has filed an affidavit in the month of April, Lordship, clearly stating that the matter has been submitted to the Secretary to the Government of Nagaland Works and Housing Department, Nagaland Kohima, which is at page 7 of the affidavit in opposition filed by respondent number 2, Lordship. As Lordship has got page 7, annexure 1, Lordship.
yes,
As Lordship has got it, Lordship.
yes.
Lordship, I may allow to read, Lordship.
Yeah.
To the Secretary to the Government of Nagaland Works and Housing Department,
Nagaland, Kohima. Subject: submission of details of temporary NPWD cadre employee under PWD R&B Parent Division for registration in PIMS portal. Sir, with reference to the subject cited above, I am submitting herewith the detailed information of two temporary NPWD cadre employees not having PIMS code under EEPWD R&B Parent Division for registration in the PIMS portal. The detailed information along with the necessary documents are enclosed by the next year A. This is for favor of your kind information and further necessary action, please. And Lordship, the next page is a type copy. Page 8 is a type copy. And Lordship may skip that one, and Lordship may kindly come to page 9, Lordship. Page 9. Page 9, and the type copy is at page 10, Lordship. It will be more clear, Lordship. Type copy is at page 10. Lordship may come to serial number, starting from serial number 5. First name, I. Middle name, 6. Temjan. 7. Last name, Jamir, Lordship. So now, Lordship, and Lordship may appreciate, and Lordship is well aware that the PIMS, the PNR is the nodal department, Lordship. To the PIMS is Personal Information Management.
No, you have
System.
taken steps for releasing of the salary. That is your submission.
Until and unless
But-
their employment code is registered under the PIMS.
No, but where is the speaking order which you had to communicate to the petitioner that I am doing these works, I am taking these steps. The direction was to you by the writ court that you will dispose of the representation by a speaking order and communicating a copy of the speaking order to the petitioner. That was the direction.
Lordship, in that way of the matter, Lordship, I may allow some time to do the necessary.
Though you have taken steps, but you have to communicate to the
Lordship.
petitioner that I have considered your representation and these steps I have taken.
Yes, Lordship.
That has to be communicated.
Yes.
To the whether you have done that.
Lordship has rightly pointed out, Lordship. To that effect, Lordship, since we have filed in the form of affidavit, we did not feel that it is necessary. But however, Lordship has rightly pointed out, we will do the necessary as directed by His Honorable Court by order dated 14/12/2020.
Yes, Mr.
By speaking order, Lordship. So I may allow some time, Lordship, to do the needful.
Anything?
If I may, Your Lordship, with regard to the issuance of PIMS court, Your Lordship, in the representation that I have
No,
submitted.
they have not communicated to you what steps they are taking.
Yes, Lordship.
Let them do that.
Your Lordship.
Let them do that. It appears that they are taking some steps.
Yes, Your Lordship.
But that was not the order. Order was to dispose of the representation by a speaking order so that you know what steps the government is taking.
Lord.
Yes, Mr. Zamir.
Yes. And Imchin, Your Lordship.
Sorry, Imchin.
Your Lordship, I'm representing the state respondent 1 and 3 here. And I concurred as the affidavit, the contra affidavit filed by respondent number 2. But one thing is that once a regularization process has been started, it has to be started from the department and it ends in the Personnel and Administrative Reforms Department. And once a person has been regularized, PIMS, that is the Personal Identification Management Number, has to be given. Only then that particular person can draw the salary. That is why, as per the direction of the court, we have taken the initiative. The department.
No. Court's direction was specific. Court's direction was not only to take steps. Court's direction was to dispose of the representation by a speaking order so that petitioner knows what steps you are going to do.
That is
take.
That is why, Your Lordship,
while disposing of the representation of the petitioner, that is for the regularization, we have to take the steps. And it ends with the Department of Personnel and Administrative Reforms. Because we cannot simply regularize a person, department. It has to go to the PNR. The process is on, and initiative has already been taken, and it is lying for giving the BMS number only. So once BMS is given, then you can join the service and without a salary.
You inform her in person. You comply with the direction of this court, the writ court, in letter and spirit. It is not that only you are taking steps and she does not know what steps the government is taking. Because the order against which this contempt has been filed specifically directs the respondent number 3, 4 and 5 to dispose of the representation with a speaking order.
While considering the representation, it has to be noted in the.
Yes, no, what steps you are going to take, you may mention it in your speaking order. So that petitioner has, so you are praying for time. Had Miss V. There. This is item number 4. V. There, learned counsel for the petitioner, contempt petitioner. Also, Mr. V. Zimomi, appearing for respondent number 2, and Mr. Moa M. Chen, learned senior government counsel, appearing for respondent number 1 and 3. Learned counsel for these respondents have prayed for 3 weeks' time to comply with the order. The learned counsel for the respondent have submitted that the respondents have already taken steps for releasing of the salary of the petitioner. However, they also prays for 3 weeks' time to comply with the order dated, which is the
14/12/2021.
14/12/2021, passed in writ petition number
338 of 2021.
338 of 2021. Learned counsel for the petitioner does not object to the said prayer. Hence, prayer is allowed. Let this matter be listed after 3 weeks. Before that, mention one line. It is also submitted by learned Mr. V. Zimomi, learned counsel for respondent number 2, that the matter of the petitioner has forwarded to PNRD department for consideration in PIMS records, and thereafter, after 3 weeks.
For admission, item number 9.
Yeah, please, Your Lordship. This is a short matter. Matter relates to non-release of second and third installment for construction of Nagaland Film Institute building at Dimapur. Initially, in 2017-18, the Government of India has sanctioned a sum of rupees 203 crores for construction of the building, and it is a 100% centrally sponsored scheme. And basing on the progress report, the physical verification, the first installment has been released in two fractions, which is about 40 point something lakhs, and altogether 80 lakhs 20,000 as first installment has been released, basing on the physical progress of the work. However, second and third installment has been kept on hold, and the project itself was also kept on hold on the ground that the state government have not included this project as one of the priorities in the state priority list, which can be submitted to the NEC, and the NEC will release the fund. And to release the fund, the UC, that is utilization certificate, is to be furnished. Thereafter only the fund will come.
Who will furnish the UC?
Unfortunately,
Who has to furnish?
State government. Unfortunately, the state government has not, that is the planning department who are dealing with this. They have not furnished included in the list. So a legal notice has been issued by the counsel of the petitioner. And after issuing the legal notice, NEC has requested the planning department, government of Nagaland, to include this project, since this is ongoing, to include in the list, priority list. Because for execution of any project, it has to be included in the state priority list. Unfortunately, the state have not included in the state priority list. Again, the NEC has reminded the state government to include it in the state priority list. That was not included. Therefore,
state priority list of what?
For the
projects.
Centrally sponsored schemes.
Okay.
All the projects are to be included in the state priority list. So ultimately, having failed to get any relief, the writ petition has been filed for seeking a direction to the respondents to release the second and third installment. Now,
where is your prayer?
Page 11, second paragraph. Page 11. Has your lordship got it?
Yes.
Second paragraph. Direct the respondent authorities to release the pending second and third installment for the proceed project, which is amounting to 1.2 crore for completion of the ongoing construction of film studio at Dimapur. So that is the prayer. Now, during the pendency of the writ petition, the NEC has taken some steps in connection with the payment of the pending bills, and this Honorable Court was pleased to pass an order on 4th July 2023. Kindly, Lordship, may have a look at that order. That is 4th July 2023.
Yes.
Ending part will be relevant, and in the last line, the letter dated 6/2023 shall place on record. I do not know whether Lordship is having that document. It has been placed on record as per the last order, 6 June 2022. 23, sorry. If it is not available, readily, Lordship, I am placing a copy of the letter.
It is not there.
A copy has been endorsed to the petitioner also. letter.
Yes.
Yes, as per this letter, it is clear that a decision has been taken by the competent authority to clear the outstanding liabilities. That is one. The second
Competent
point-
authority is, NEC is the competent.
Yes, Lordship. They are the funding agency. Secondly, the implication of this letter is the council have been directed to inform this honorable court about the decision of the competent authority to make the payment. Number one. The another implication of this letter is a request has been made to persuade the petitioner
To withdraw.
to withdraw the case. Now, up to this, the order dated 4/7/2023, which I have just referred to, Your Lordship, that order has been passed on 4/7/2023, directing my learned friend to obtain instructions.
How much time?
How much time will be required for making the payment. After that, they have filed affidavit in opposition on 18th of July 2023.
Oh.
And in paragraph 13 of the affidavit in opposition, Lordship will find in categorical terms, the Union of India and the NEC has made a statement that the competent authority has taken a decision to release the outstanding bills in order to facilitate the completion of the project. So, Lordship, in view of this statement, this writ petition can be disposed of with the direction to the respondent number 1 and 2 to release the second and third installment within a specified time, Lordship, so that the project will be executed as per the scheme. And going by the work order, the period of completion was given 24 months, that is 2 years. And in the meantime, Corona, all these things, pandemic were also there.
Now what?
And there were some lapses on the part of the state, laxity on the part of the state government to include in the state priority list. But ultimately, the funding agency has taken a decision to release the outstanding bills. So in view of this statement, this writ petition can be disposed of, Lordship, giving a short time to the respondents to comply with the.
How much time? How much work is remaining?
40% of the work has already been done. I have enclosed in the writ petition the progress, the photo of the construction also, but those are not relevant at this stage. But 40% of the works have completed. And once the fund is released, definitely within a short time, we'll be able to execute the works.
On last occasion, Mr. Yangarwati, you were, a request was made to inform this court as to within how much time this fund would be released. You were requested to inform this court, the
Yes,
time
yes,
required.
I have received this letter only, which is with your lordship. In fact, lordship, the project has been delayed not because of the NEC, but because of the state government. They have not put up the project in the priority list. That is why it has been delayed. Otherwise, in spite of which the NEC has taken a decision to fund the project. So at this reasonable time, I will given the project. 4 months time.
Within 4 months?
Yes.
Lordship, it is not to be sure that there is no fund.
The
It's not the ground.
delay was not.
Who is the executing authority?
Executing authority is IPR, Information and Public Relations. I have met them as parties.
The state government?
Yes, state
So
government.
even if they get fund, it is their responsibility to execute the project.
Yes, lordship.
Yes.
Ours is our
They are the funding
local
agency.
funding. It's
And
issued by the
implementing
government.
agency is the state government.
Yes, Mr. Angami.
Lordship, this is a central project. It is not a state project. And therefore, as and when the central government release the fund to us, we will make the necessary payment. Your Lordship, the payment the petition is just to that extent. Just to that extent. And the direct respondent authorities to pay the pending second and third installment of the state project. Page 11, Your Lordship. Page 11.
Yes.
Direct the responding authorities to release the pending second and third installment for the aforesaid project, which is amounting to 1.2 crores for completion of the ongoing construction of film studio at Dimapur. So I said, when we receive the money, Your Lordship, we'll make the necessary payment.
Okay.
Let that be recorded, Lordship.
Yes, as and when we receive the money from the central government, Your Lordship.
Heard Mr. C.T. Zamir, learned senior counsel for the petitioner, assisted by Mr.
Aliba Ozekam.
Aliba Ozekam, learned counsel for the petitioner. Also heard Mr. Yangarwati, learned central government standing counsel, as well as Mr. N. Angami, learned senior government counsel, representing
Respondent 3, 4, and 5.
Respondent 3, 4, and 5. This instant writ petition has been filed by the petitioner, Messrs. Rainbow Construction, under Article 226 and 227 of the Constitution of India, praying for issuance of a writ in the nature of mandamus / or any other appropriate writ against the respondents, directing them to release the pending second and third installment of project which
Construction of film studio at Dimapur. Work order is at page 15.
second and third, no, before that, writ of mandamus. Instead of directing them, the instant writ petition has been filed. No, the facts relevant for consideration of the instant writ petition is that where you have mentioned the facts, that respondent number, planning and coordination department is not made party.
Dear Party Lordship, respondent number Development Commissioner Nagaland. He is representing the planning department. Respondent number 4.
That the planning and coordination department, Nagaland, Kohima, had issued a work order, right number from the writ petition, I am underlining it, dated 24/2018 to the petitioner, who is a class 1 contractor and class 1 contractor the work order was issued under the scheme Preservation and Promotion of Art and Culture of the any state, and the same was funded 100% by NEC. It is stated in the writ petition that the first installment, that in pursuant to the work order, the petitioner executed, what percentage of work order has been?
Lordship will find it paragraph 5 of the affidavit of respondent number 1 and 2.
No, where is your statement in?
Paragraph 4.
It is also pertinent, before that, it is also pertinent to mention that said work order pertains to construction of setting up of a film studio at Dimapur, and accordingly petitioner had initiated the execution of the work order and has also received first installment received an amount of rupees 81.20 lakhs as first installment for ongoing project.
I'm sorry for the interruption, Lordship. Lordship was making a query, the percentage of 40%, where can I get?
Yes.
That is at page 24. Physical progress report was on 1st July 2020. Here the 40%. Yeah.
What was the last line? No, before that, initiated the execution of the work order and 40% up and initiate the execution of work order, and up to July 2020, 40% of the said work order has been completed by the petitioner. And against the said work, the petitioner has also received an amount of rupees 81.20 lakhs as first installment of the ongoing first installment for the said project. The first installment was released in two fractions, that is of rupees 40.660 lakhs on 16/5/2018, and subsequently, after verifying the physical progress report, the second fraction of 40.60 lakhs was released with a remark as within inverted comma in good progress. Next para. Then it stopped after receipt of the first installment.
After that, utilization certificate was issued for release of the second and third installment. But thereafter, payment has not been made.
Okay.
And as per the affidavit of the respondent number 1 and 2, the work has been kept on hold in view of non-receipt of the priority list from the state government. That was the contention that respondent number 1 and 2, the funding agency has taken.
The petitioner has further contemplated in the writ petition that after receipt of the first installment, the utilization certificate was duly submitted to the authority for release of second and third installment. However, the said however, there has been inordinate delay in release of second and third installment by the concerned authority. Stop. Where it is stated that the NEC is not releasing. Second and third, there is a delay. In para 5, you have mentioned that there is a delay in releasing the second and third installment.
Yes.
Then
In paragraph 11, in view of non-payment, the legal notice has been issued.
no, because the second and third installment is not issued, you are unable to pursue further.
Yes.
Stop. And what is the quantum of amount?
100 in, the quantum of amount to be paid is 1 crore 2 lakhs.
In second and third installment. Don't write anything, huh? I'll tell. Where have you stated in writ petition
Yes.
that how much okay, I will mention.
Specific amount.
1.2, 1.2.
But we have mentioned about
In
second and
the
third.
prayer portion you have mentioned.
Yes, in the prayer portion.
Now, in view of the non-release of the second and third installment, the aforesaid, the further execution of the aforesaid project has come to the halt, and therefore this writ petition has been filed seeking a direction to the respondent authority for releasing the pending second and third installment, which amount to 1.2 crore for completion of the ongoing construction of film studio at Dimapur.
Lordship, instead of 1.2 crores, 1 crore 2 lakhs.
One crore.
Wrongly it is mentioned. If we go by this, then
Okay.
20 lakhs.
Okay, 1 crore 2 lakhs. 1 crore 2 lakhs instead of 1.2 crores. Learned Mr. N. Angami, learned Senior Government Counsel, representing the respondent number 3, 4 and 5, which is the nodal 3, 4, and 5, has submitted that as the project in question is entirely a centrally sponsored scheme, and which is a centrally sponsored scheme entirely funded by central government. Hence, unless the requisite fund is provided by the central government, that is, who will be providing fund? NEC.
Respondent number 2, that is Secretary, North Eastern Council Secretariat.
That is North Eastern Council. The state government may not be in a position to release the fund to the petitioner. On the other hand, it is also submitted that as soon as the fund is released by the NEC, there is no
North Eastern Council.
no constraint, no difficulty on the part of state government to release the second and third installment to the present petitioner. Learned, on the other hand, Mr. Yangarwati, Learned Central Government Standing Council, has placed a letter dated 6 June 2023, issued by Director within bracket Information and Public Relation, Northeastern Council Secretariat, wherein a request was made to the Learned Central Government Standing Council to inform this court that the remaining portion of the work of setting up of film studio at Nagaland would be expeditiously completed, and the competent authority has decided to discharge the remaining liability of NEC funded liability of the said NEC funded project at the earliest. In pursuant to the said letter, the respondent number 1 and 2 has also filed an affidavit in opposition, wherein
Paragraph 13.
wherein
That's 6.
it is mentioned that as the, but it is only with regard to 121.80 lakhs, wherein it is mentioned that the competent authority has, wherein it has been stated that the competent authority has decided to discharge the remaining liability of NEC funded project, namely setting up of film studio at Dimapur for rupees 121.80 lakh, within bracket 1 crore 21 lakhs 80,000. Now, is there any dispute regarding the quantum?
No, it is their statement. But in order to avoid any confusion in the prayer portion, we have only used 1.2 crores. We have to go by the letter of the authority.
They are giving you 21 lakhs. You want 2 lakhs. 21 lakhs. No, I'm repeating it. For setting up of film studio at Dimapur, Nagaland, for rupees 121.80 lakh, within bracket rupees 1 crore 21 lakhs 80,000 only, so that remaining portion of the work is expeditiously completed. And expenditure incurred so far does not become wasteful and infructuous in public interest. Stop. in view of the submissions made, in view of the averment in the affidavit in opposition made by respondent number 1 and 2, it is submitted at bar. You don't have any opposing views. It is submitted at bar that this writ petition may be disposed of, giving a direction to the respondent number 1 and 2 to release the outstanding due of rupees 121.80 lakh within a reasonable period of time. Stop. Considering the submissions made by learned counsel for the parties, as well as considering the averment made by respondent number 2 and 3, 1 and 2 in their affidavit in opposition, and also taking note of the letter issued by the Director Information, within bracket Information and Public Relation, Northeastern Council Secretariat, to the learned Central Government Standing Council on 6th of June 2023. This writ petition is hereby disposed of with a direction that the respondent number 1 and 2 shall immediately disburse the remaining liability of NEC funded project, namely, to whom you will be disbursing?
Director Information and Public Relations.
Disburse the, what was the last words? Namely, setting up a film studio at Dimapur, Nagaland for 121.80 lakhs to the respondent number
4 and 5.
4 and 5
Yes.
within a period of
1 month is
within a period of 4 months. 4 months.
That is-
When you have taken decision, why so long?
that is why, Lordship.
Because the delay, as I have said, was not caused by me.
No. Now you have money and you have decided. You have decided big. Then why 4 months is required? 4 months will.
It's a huge amount of money.
But you have not stated that money is not with you.
Let it be 1 month. That will be a reasonable period.
Within a period
I am
of.
bleeding 1 month. My learned friend is bleeding 3. Let us meet in the halfway. That let it be 2.
Within a
2
period.
months. That is a reasonable period.
Within a period of 2 months from the date of this order, and on receipt of the said. You are trying your best.
From today.
No. When Central Government Standing Council is there before this court, who can immediately convey it,
Yes.
date of the order. Date. That I will mention. Date of this order and receipt of this, on receipt of the said fund, respondent number 4 and 5 shall release the second and third installment of the outstanding due to the petitioner immediately, so that the remaining project of setting up a film studio at Dimapur may be completed at the earliest. Let a copy of this order be furnished to learned Central Government Standing Council. With above observation, this writ petition is hereby disposed of.
Much obliged.
For addition, item number 13.
May I please, Lordship? Lordship kindly allowed me to withdraw the petition with the liberty to file afresh.
Why?
My client has given instruction to
Okay.
development of some
Heard, Mr. What's your name?
Atiba.
Ati?
Atiba, my lord.
Atiba? Heard, Mr. Atiba, learned counsel for the petitioner, who submits that the petitioner may be allowed to, who submits that he has instructions from his client to withdraw this instant writ application with a liberty to file afresh, if required. Also heard Mr. AIME, Miss AIME, learned
State Council, Your Lordship.
learned
Respondent 1 to 5.
learned government counsel representing respondent number 1 to 5, who does not have any objection to the prayer made by learned counsel for the petitioner. Considering the submissions made by learned counsel, this prayer is allowed. This writ petition is hereby dismissed on withdrawal with the leave as prayed for granted.
For admission from the supplementary post list, item number 34.
Lordship, if the matter committing around after the first matter, Lordship.
After?
The council there, Your Lordship. Lordship, the councils are here, Your Lordship. If the matter can be taken up after 15 minutes, Your Lordship.
Okay, okay.
For orders, item number 14.
I've prayed for leave. We mentioned our prayer for listing the matter. The truth, Lordship.
None appears for the appellant. Heard Mr. K.V. Angami, learned public prosecutor, who prays for
3 weeks, Lordship.
3 weeks' time for taking necessary instructions. Considering the submissions made by learned public prosecutor, Nagaland, the prayer is allowed. Let this matter be listed after 3 weeks.
Thank you, Lordship.
For orders, item number 17.
May I please, Your Lordship. Your Lordship, in the last order, your interim instance, Your Lordship, all the parties they have agreed, Your Lordship. Order dated 8/6/2023, Your Lordship. Your Lordship, for respondent 1, 2, 3, 4, 3 and 4, Your Lordship, all the respondents have agreed, Your Lordship. Notice has been completed, Your Lordship. The matter.
Your Lordship, allow me 2 weeks' time.
For filing affidavit in
I'm
opposition.
representing the respondent number 2.
Lordship, I am for respondent number 1.
Heard Mr.
Lordship, I'm sorry. I'm representing respondent number 2 and 3.
And Mr. Angami, you?
I am for respondent number 1.
And Mr. Zimomi?
For respondent number 4.
Respondent number? Heard Mr. N. Solo, learned counsel for the petitioner. Also heard Mr. Moa Imchen, learned senior government counsel, appearing for respondent number 2 and 3. Also heard Mr. N. Angami, V. Zimomi, appearing for respondent number
2 and 3.
2 and 3. And Mr. N. Angami, learned senior government counsel, appearing for respondent number
1.
1. Now, all the respondents want time for filing affidavit in opposition. Learned Counsel for respondents prays for 2 weeks' time for filing affidavit in opposition, which is not opposed to by the Learned Counsel for the petitioner. Hence, the prayer is allowed. Let this matter be listed again after 2 weeks.
For admission, item number 34.
May it please Lordship. Lordship is a very short matter, Lordship. I'm praying for regularization of my service, Lordship. I'm serving as a sweeper on contingency basis, Lordship, and PWD department. Now I'm putting in service for around 33 years, Lordship. I'm on the verge of complete retirement, Lordship. Now the respondent, they have not considered my case. Lordship, what has happened is, Lordship, I'm the senior most sweeper in the division.
Yes. Yes, Mr. Zamir.
Some of my juniors, they were already regularized, Lordship.
Acha, why you, Mr. Imchen, you are appearing for the state respondents?
Yes.
Whether it can be disposed of at admission stage or should it go to hearing? Yes, what is your response?
What is the response?
Lordship, I've filed my counter, looking bills, my counter.
No.
Lordship, the pleadings are complete, Lordship. I have filed a reply and he has filed his affidavit. It can be disposed at admission stage, Lordship. It is a very simple matter, Lordship. And I'll also finished 2 or 3 decisions, Lordship, which covers my case. In fact, a letter is...
You are ready?
I'm ready, Your Lordship. I'm ready.
Okay. Then we will hear.
Lordship, it will take only 30 to 40 minutes altogether, Lordship.
Okay.
May I check your Lordship?
30 or 40 minutes means it will take 1.5 hours.
I'll try my best to reduce the time, Lordship.
Okay.
I'll make an attempt, Lordship. If your Lordship may allow me to turn to page 9 of the petition. Read petition, Lordship.
Yes. Just a minute.
This is an order dated 29 of June 1990, Lordship.
What is the name of the petitioner?
Chupamongla, Lordship.
Chupamongla.
Yes, Lordship. Chupamongla, our Lordship.
Yes.
Lordship. This is the initial appointment order of the petitioner, Lordship. It is order dated 29 of June 1990, Lordship. 29 of June 1990. This order was issued by the estate officer, PWD Housing, Lordship. May I read the order, Lordship? It is a very short order.
Yes.
Shrimati so-and-so of Mangutum villages hereby appointed as sweeper on contingency basis in the scale of pay of so-and-so, plus all other allowances as admissible under rules from time to time, to similar post in force in Nagaland with effect from the date of joining the post. The appointment is purely on temporary basis and liable for termination without any notice. So this is the initial appointment order. I was appointed on the 29th of June 1990 and I have completed 33 years in the month of June 2023, Lordship.
Okay.
Lordship, I have completed 33 years of service, Lordship. I am still continuing in service, Lordship.
On contingency basis?
Yes, Lordship, on contingency basis. I'm still serving as sweeper on contingency basis, Lordship.
Yes.
Lordship, is the next page, Lordship. I was granted time-bound scale, Lordship. Page 10, annexure 2. Lordship will find a type copy at the next page, that is page 11, Lordship.
Yes.
This is dated 30th of October 2009. 30 October 2009, Lordship.
Yes.
May I read it, Lordship? It is hereby notified that the following grade for government serving employees under the establishment of Senior Assistant Estate Officer PWD Housing, Mogokchung, Nagaland, having completed 15 years of continuous service. In the relevant main grade, I have become entitled to the revised time-bound scale in terms of Rule 13 of the Nagaland Government Service RP Rules 1993. So, after completing 15 years of service, I was given this time-bound scale by this order, Lordship. My name features at serial number 1, Lordship.
Yes.
Now, in the year 2019, I have submitted representation to the respondent authorities, page number 12, Lordship. Lordship will find the representation at page number 12, Lordship. This is the representation addressed to 3 of the respondents, Lordship, praying for regularization of my service, Lordship. At this point of time, I had put in service of 29 years, Lordship, when I submitted this representation. My simple prayer was limited to regularization of my service.
Yes.
Lordship. Next, if your Lordship may kindly turn to next page, page 13, Lordship. Page 13. This is a certificate issued by the Senior Assistant Estate Officer. Lordship, this is very important as regard to my service, Lordship. This is to certify that Chairman is so-and-so under the establishment of the State Officer PWD Housing, Mogokchung, is serving under this establishment for the last 29 years in the same capacity, Lordship. It is also stated that she is the senior most sweeper on contingency basis and there is no blemish record against her. The incumbent is performing her duties sincerely and diligently. This shows that I'm the senior most in the establishment. However, my case was not considered and there is also no blemish record against me, Lordship. This is the authority which has issued. Now, Lordship, may kindly turn to page 14. Page 14. This is the senior list of contingency staff under Senior Estate Officer, PWD Mogokchung, Lordship. So my name features is serial number 2. I'm the only sweeper, Lordship, and date of training is stated as 30th of June 1990. So the others are painter, SA, Lordship.
But you are at serial number 2.
Lordship, as far as sweepers concerned, I'm the senior most, Lordship. They maintain different senior lists as with regard to different posts, Lordship.
No, in the establishment of, where do you work?
I work under the establishment of PWD Housing, Mogokchung, Lordship, under Senior Assistant State Officer, Lordship.
So how many sweepers are there in that establishment?
Lordship, I'll also show the number of sweepers.
There are more sweepers?
Yes, Lordship, there are more sweepers, Lordship. Lordship, before coming to that, there is an office memorandum which is also relevant for this case. If your Lordship may kindly turn to page 15. This is office memorandum dated 17 March 2015.
Yes.
This is dated 17 March 2015. This is common policy formulated by the Government of Nagaland, Personnel and Administrative Reforms Department, Lordship. The subject is scheme for regularization and absorption of work, church and casual employees and revision of pay and wages, Lordship. So this is as per the subject, it pertains to work, church and casual employees, Lordship. So the clause 1 of the office memorandum, if I may be allowed to take your Lordship to regularization and service. Command 1, Lordship. All existing work, church and casual employees of various departments who are enjoying skilled pay and who have completed 30 years or more continuous service as on 1/1/15 will be regularized by conversion of the post into regular ones personal to them and subject to fulfillment of conditions as indicated below, Lordship. Now, as on 1/1/2015, I have not completed 30 years, Lordship. But there is also a provision, if your Lordship may kindly turn to page 16, the next page, Lordship. Roman 2, the top Roman 2, Lordship. If your Lordship got it. This covers my case, Lordship. In respect of those both church engagement employees in scale pay and who have completed or will complete 30 years of continuous service after 1/1/2015. This is relevant in my case, Lordship. Their cases for regularization will be taken up subsequently in 2 batches as on 1st of July and 1st of January every year. The procedures and terms and conditions will be the same as laid down in this office memorandum. So this office memorandum has laid down a policy that whoever completes 30 years of service and who enjoys scale of pay.
You have not completed 30 years.
I have completed 30 years. In fact, I have completed 33 years, Lordship.
33 years.
33, Lordship. In the month of June 2023, I have completed 33 years. Since my appointment was in the year 1990, Lordship.
Okay.
So this also covers my case. And as far as this OM is concerned, Lordship, there is also a judicial pronouncement of this court, Lordship, a division bench of this honorable court, where the case is also reported in Nagaland Law Journal, Lordship, at page number 368, Lordship. I'll be relying on that judgment, Lordship.
What is the citation?
Lordship, Nagaland 2023, volume 1.
You will be taking up it later on?
Lordship, yes, later. I'll come to that, Lordship.
Okay.
Lordship. So this is the office memorandum that covers my case, Lordship.
What it says in respect of those work charge employees, scale of employees.
And
so your grievance is that state has not regularized you pursuant to this clause 2 of 1H.
Yes, and if I may be allowed to tap your Lordship to 1G, Lordship, G, that Lordship will find at page 15.
Yes.
If I may read it, Lordship.
Yes.
This scheme shall, however, not be applicable to the part-time casual employees, village cards, home cards, ICDS workers, and other CCS paid employees whose services are guided by specific terms and conditions laid down by the government, and some other categories of contingency employees like personal peons, part-time, joggetters, sweepers, seasonal workers, Lordship. I'm not a part-time, Lordship. I have rendered my service for the last 33 years, Lordship.
So you do not fall within the
exception.
exception?
I do not fall under this exemptions, Lordship. So this OM squarely covers my case. That is the humble prayer before this honorable court, Lordship. If I may be allowed to take your Lordship to what has happened in the department with regard to appointment of regular sweepers in the department. If your Lordship may kindly allow me to take to page 20 of my petition, Lordship. I'm coming towards the end of the facts, Lordship, in this case, Lordship. I have received this list of all regular sweepers in the department appointed from June 1990 to September 2019, Lordship. This is Annexure 2. I have obtained this information through an RTI application, Lordship. And the department has furnished me this list, Lordship.
Okay.
So it shows that as many as 42 regular sweepers were appointed in this intervening period of 1990 to 2019, Lordship. A total of 42 regular sweepers were appointed, Lordship. And my grievance, Lordship, the discrimination.
These 42 were appointed in PWD?
Yes, Lordship, the same department, Lordship. Okay. Of course, different divisions, Lordship, all over the state.
Okay.
Now that shows that there were vacancies in the department all along, Lordship. And the discrimination.
Or date of appointment is also mentioned.
Yes, Lordship.
So after your representation, was there any appointment?
Yes, Lordship.
You submitted
2019. I have submitted 2019, Lordship. And 2 appointments were made in the year 2019, Lordship.
Yes.
Lordship. And the action of discrimination, Lordship, how the department, they have discriminated me, how they have regularized this juniors, Lordship. Lordship will find it page 22. Page 22. List of contingency sweepers regularized from June 1990 to September 2019, Lordship. These are the names of 10 sweepers, contingency sweepers, who were appointed only after my appointment, Lordship. These are all juniors to me, Lordship. Now, Lordship will find a column, the third column, date of training, 1999. The second is 1990, that is November. The third is 1992. The fourth is March 2001. Fifth, August 2016. Sixth is March 2004. Seven is March 2010. 8, January 2004. 9 is June 2013. And finally, 10 is May 1992. All these are appointments made after my appointment, Lordship. All these are juniors to me.
Initial appointment, all are were junior to you.
Yes. My initial appointment was in the year 1990. All these were appointed after my appointment, Lordship.
Okay.
And they were regularized. Date of regularization is also given, Lordship. At the 5th column, Lordship. Date of regularization. 2012, 2017, 18, 14, 16, and 12, Lordship.
Okay.
These are the years, and this clearly shows that my juniors were considered, Lordship. And one of the instances, I have also shown one of the regularization orders at page 23. This is also one of the instances where one of my junior was also regularized, Lordship.
Yes.
And at the time of filing this writ petition, I have furnished some vacancies, Lordship. However, it pertains to 2019. I filed it in the year 2020, Lordship. So 3 years is almost about to lapse, Lordship. And this, my apprehension that this vacancies might have been filled by the department, Lordship. Anyhow, my prayer still stands, Lordship. Now, the state has filed an affidavit in opposition, Lordship.
What is their story?
They have raised only 2 contentions as far as their affidavit is concerned, Lordship. Only 2 contentions, that this OM does not apply in my case, and there is no common policy as far as contingency employees are concerned, Lordship. These are only 2 contentions raised by the state, Lordship.
This 2015 OM is not applicable.
In my case, that is the first contention.
Why?
Second,
why?
For the reasons passed on to the respondents, Lordship.
They have not explained the reasons in the affidavit.
Lordship, I have explained, and the OM is also very clear.
They have not stated why it is not applicable.
Yes, Lordship. Yes, Lordship. They have not stated why it is not applicable.
Okay.
Only a simple contention, affirming in the affidavit, Lordship, and the second is there is no policy for regularization of contingency employees in the state. That these are only 2 contentions raised by the state respondents, Lordship. However, the authority which I'm going to rely on, Lordship, it is very clear. If I may be allowed to rely on the first authority, it was, this order was passed on 18th of February 2022 by the Honorable Apex Court, Lordship. Apex Court. It is just 1-page order, Lordship. May I read it, Lordship?
Yes.
It is unfortunate that the state continued to take the services of the respondent as ad hoc for 30 years, and thereafter now to contend that as the services rendered by the respondent are ad hoc, he is not entitled to pension or pensionary benefit. The state cannot be permitted to take the benefit of its own wrong. To take the services continuously for 30 years and thereafter contend that an employee who has rendered 30 years continuous service shall not be eligible for pension is nothing but unreasonable. As a welfare state, the state as such ought not to have taken such a stand. In the present case, the High Court has not committed any error in directing the state to pay pensionary benefits to the respondent who has retired after renting more than 30 years service. Hence, the SFP stands dismissed pending application if any shall stand disposed of. The principle applies in my case, Lordship. Even in my case, I have rented for 33 years, and in this case, Lordship, it is a recent judgment, Lordship, where the state has to appreciate, and they have utilized my service for more than 30 years. Now they cannot deny the benefit for the fruits of labor I have rented for the entire 32 years of service, Lordship.
Okay.
The second, Lordship, this is with regard to the state or state of Nagaland, Lordship, WPC 112 2019, Lordship.
Just a minute.
I'll be relying only on 4 paragraphs, Lordship. 18, 22, 24, and 26, Lordship.
Para 18?
18, 22, 24, and 26, Lordship.
Yes.
Lordship will find paragraph 18 at page 15. Page 15, Lordship.
Yes.
If your Lordship got it, paragraph 18. May I read it, Lordship?
Yes.
Contingency is referable to a situation where there is need of service at certain emergent time. However, to suggest that the petitioners have been placed for 34 years and 6 months on contingency basis is nothing less than enslavement. The respondents have utilized the services of the read petitioners continuously, and nowhere in the records it has been reflected that the petitioners suffers from any disciplinary defects or they are not qualified and that they are incapable of performing duties which are performed by regular employees. Both the petitioners have been discharging the same duty performed by regularly employed servants for the past 34 years. Nature of work that is performed as peon in Jokita does not require any specialist skill and can be performed by anybody who has normal disposition. Contingency is defined as in the dictionary as a future event or circumstance which is possible but cannot be predicted with certainty. Apparently, the intent of the respondents is to use the services of the petitioners as and when the needs arise to utilize the service. 34 years and 6 months of continuous service covers the prime life of petitioner, and to send them home empty-handed is nothing less of exploitative enslavement. One cannot accept the argument that the petitioners were placed on contingency services for such a long period of time since the establishment of the office of the Inspector of Schools, Zonipado. In the light, the spirit of the judgments of the Apex Court, the petitioner must be given equal pay for equal work. Now, Lordship, if I may be allowed to rely on paragraph 22, page 20, Lordship. Paragraph 22.
Yes. Yes.
Page 20, Lordship. May I read it, Lordship?
Yes.
The Honorable Supreme Court, while considering the rejection of the claims for regularization of a set of special police officers who have the same power, privilege, and protection and liable to perform the same duties, but so refused on the sole ground that they were not appointed against any sanctioned vacant post, have expressed a view that sanctioned posts that do not fall from heaven, and the state has to create them by a conscious choice on the basis of some rational assessment of their need. The Honorable Supreme Court, while considering the claims for regularization by the High Court of Punjab and Haryana, on the ground that there is no regular cutter or sanctioned post available for regularization of their services, held that the High Court may be factually right in recording that there is no regularly constituted cutter and sanctioned post, but however that does not conclusively decide the issue on hand. A view was expressed that creation of a cutter or sanctioning of post for a cutter is a matter exclusively within the authority of the state. And that the state did not choose to create a cutter, but choose to make appointments of persons by creating a contractual relationship only demonstrates the arbitrary nature of exercise of power. The Honorable Supreme Court, while considering the usual view of the state authorities that in the absence of essential post by the state cannot be compelled to observe persons into the services of the state, expressed that the posts are to be created by the post, depending on the need of employee, people having regard to various functions the state undertakes to discharge. A quotation was made from the 42nd American Jurisprudence, page 902, par 31. Every sovereign government has within its own jurisdiction right and power to create whatever public offices it may regard as necessary to its proper functioning and its own internal administration. Para 24, Lordship. Para 24. The stand of the respondent state that such temporary employees have accepted to offer employment
Yes.
at the lower wage on their own volition, and that they are working against they are not working against an essential post, and as such not entitled to regular scale pay or regularization is as such not acceptable. Para 26, Lordship. Lordship will find it on page 22, Lordship. The last paragraph, Lordship.
Yes.
May I read it, Lordship?
Yes.
The services of the petitioners were utilized by the respondents without break for the past 34 years and 6 months, with no records of blemish. In spite of the directions of the Honorable Apex Court to make exercises within 6 months of the passing of the Umar Davis case on 10/4/6 to regularize all irregular appointments, the respondents indulged in continued contractual appointments, thus committing contempt. Also, in line with the Apex Court's ruling in Nihal Singh's case, this court can only come to the conclusion that as the post of Jockeyter and a peon is not a contingent post, an integral requirement on the daily basis in offices such as the office of the district education officer, there is a requirement to create such post. This court is also conscious of the fact that the sanctioned posts in the office of the petitioners were reserved for future candidates without considering the petitioner's case. Both the petitioners performed the same duty as the candidates who were appointed after them. The only difference is that the petitioner held contingency post and the others who were appointed against sanction post. The nomenclature of the post is same and they perform the same nature of duty. They are entitled to get equal pay for equal work as such. If I may be allowed to conclude here, Lordship. So this is the decision rendered in the case of WPC 112 of 2019. This also squarely covers my case. The petitioners in this case were also serving as contingency employees, Lordship. They served for 34 years and 6 months, Lordship. And the direction was given to regularize their services, Lordship. And this squarely covers my case, Lordship. I may be allowed to rely on the last authority, Lordship. It's reported in 2023, 1 Nagaland Law Journal, page 368, Lordship. This is a division bench judgment, Lordship.
Just a minute.
Lordship, before coming to the paragraphs, Lordship, if I may be allowed to highlight about the facts, Lordship. In this petition, Lordship, 6 petitioners were there. They were serving as drivers on contingency basis, Lordship. They also invoked, their prayer was, before this Honorable Court, was to regularize their services, Lordship. In terms of the 2015 office memorandum, this Honorable Court has also, Division Bench of this Honorable Court has also made an observation that after they complete 30 years of service, they may be regularized, Lordship. Since in this case, Lordship, the petitioners, they have not completed 30 years, but the OIM squarely covers their case, Lordship. To come to the facts, Lordship, if I may be allowed to rely on paragraph 4, Lordship. Paragraph 4. This is about the facts of the case, Lordship. The case set out by the read petitioners, who were 6 in numbers, was that the petitioner number 1 was initially appointed as driver on contingency basis on a monthly wage of rupees 1,500 and temporarily attached with so-and-so under the state planning machinery and under the planning and coordination department, Nagaland, Kohima, White Order so-and-so. So this is basically about the appointment, the nature of the appointment, and they are still serving as contingency employees, Lordship. If I'm allowed to take your lordship to the paragraph 5, lordship. Their prayers before this court, lordship. It was the case of the petitioners that they were entitled to regularization in terms of the office memorandum dated 17 March 2015. This is the OM which I'm relying on, lordship. Along with the office memorandum dated 22/9/2004. The petitioners have also mentioned in the writ petition that on 6/6/16, the PNAR department had notified a ban on appointment on contractual basis, declaring inter alia that any appointment made on contract basis shall be null and void. It is the further case of the petitioners that in spite of the said office memorandum, when 2 vacancies arose in the year 2018 and another additional vacancy arose in the year 2019, the respondent authorities illegally appointed the respondent numbers 3 and 4 on contractual basis for a period of 1 year till the interview is conducted, whichever is earlier, white order number so and so. Further to the surprise of the petitioners, on the same date, another order was passed, that is order so and so, whereby the respondent numbers 3 and 4 were also appointed on the same vacancies on temporary basis, subject to regularization by the Departmental Recruitment Board. 6. The petitioners, being aggrieved, had submitted a representation on so and so, praying for cancellation of the impugn orders of the appointment to the respondent numbers 3 and 4, and to consider a case for regularization. In accordance with the Office Memorandum 2015, the said representation having not been taken into consideration by the respondent authorities, the writ petition was filed by the petitioners before this court, lordship. Now the relevant paragraph, lordship. Paragraph 30, lordship. You will find it page 382. 382, lordship.
Yes.
Lordship. Paragraph 30, lordship. On the basis of the above findings, an important issue further arises for consideration as to whether the posts which have fallen vacant in view of the setting aside of the appointments of respondent number 3 and 4, the appellants in writ appeal 6 are required to be taken into consideration for regularization of the services of the petitioners. The appellants in writ appeal 15 or said posts are required to be filled up in terms of the direct recruitment by the MPSC. Clause 1 Roman 2 of the Office Memorandum dated 17 March 15 stipulates that it is applicable to those work, church, and casual employees who have completed or will complete 30 years of continuous service after 1/1/15, meaning thereby the right of the petitioners, writ appellants to be regularized would only arise after they enter 30 years of.
One query. In terms of the said OM,
lordship,
whether have you completed 15 years on 1/1/2015?
I have not completed 30 years as on 1/1/2015, lordship. I have completed only 25 years as on when the office memorandum was issued. However, there is also a specific clause where after
will be completing.
I have already completed 30 years.
No, no. The clause, what that clause says, clause 2.
Lordship.
Clause 2 says that those who have completed 30 years
as on 1/1/2015,
to them the office OM will be applicable.
Lordship.
And the second category is? You
category.
do not fall in that category that you have completed 30 years on 1/1/15.
Lordship, the first clause, it does not apply to me. Yes. For the fact that I have not completed 30 years as on 1/1/2015. But there is also a clause in the office memorandum itself that says that after the persons who complete 30 years after 1/1/2015 can be regularized on 2 batches. The first July and
After
1st of January. Yes, Lordship. After 1/1/2015, Lordship.
When? No time frame was given.
No time frame. Because it is on regular basis, Lordship. Every year this verification is carried out by the departments, Lordship. Every year. Who completes 30 years after 1/1/2015, they carry on the verification process, Lordship. So my case should have been considered, Lordship. That is my contention when I have completed 30 years, Lordship.
Okay.
Now, it has also made an observation, Lordship, if I may be allowed to continue this paragraph, Lordship. stipulates that it is applicable, Lordship, I'm starting from the fourth line, Lordship. Or third line, clause 1, Roman 2, Lordship. The third line, Lordship.
Yes.
Clause 1, Roman 2 of the office memorandum dated 17 March 15 stipulates that it is applicable to those work church employees and casual who have completed or will complete 30 years of continuous service.
This category will complete.
Yes.
In
after 1/1/2015, Lordship, it is mentioned.
Okay.
Who have completed and will complete 30 years after 1/1/2015, Lordship.
Okay.
Meaning thereby the right of the petitioners, read appellants to be regulars will arise only after they rendered 30 years of continuous service, Lordship. This is very clear. And at present, the petitioners are yet to complete 30 years of service. In that petition, Lordship, they are yet to complete 30 years, Lordship. Whereas in my case, Lordship, I have already completed 33 years, Lordship. Taking into account that the petitioners at present are not eligible.
So when you completed 30 years, on which date?
2020, Lordship, June 2020, Lordship.
Okay.
In the month of June 2020, Lordship. So my right to be considered arose in the year 2020, Lordship. I have made a representation when I have served only 29 years of service, Lordship. It was in the year 2019, my representation, Lordship.
Okay.
That is my simple case, Lordship. These are the authorities that covers my case, Lordship. And I have already completed 30 years of service.
Yes, Mr. Imchen. No response to your representation was given?
No response, Lordship. No response. And I have waited, Lordship, for a reasonable period of time, Lordship.
But you made the representation before completing 30 years?
Yes, Lordship. Yes, Lordship. I agree, Lordship. I have to admit that fact. I have served only 29 years when I have met a representation, Lordship.
Yes, Mr. Imchen.
Lordship, the petitioner was appointed on 29 July 2000.
29 June.
29 June 1980. And so as of today, as my learned friend has said, the petitioner has completed 30 years of service as of today. And this year, June, she has completed 30 years. Now, the OM, which has been relied by the petitioner, Your Lordship, the OM.
2015 OM.
This OM, which has been relied on by Leonard Frank, relates to regularization of work church in casual employees. Work church in casual employees. But the OM itself is not applicable to the petitioner because the petitioner is a contingency employee.
Now, what is the difference between contingency and work charge?
But if your Lordship say that,
No, your first contention is that
OM itself is not applicable to the petitioner.
Because
of the simple reason that this OM is scheme for regularization and absorption of work charge and casual employees. So what I mean to say, Your Lordship, OM itself is not applicable to the petitioner because the petitioner is a contingency employee, Your Lordship.
Okay.
And number two, Lordship, there has to be a policy because this is a case of regularization. There has to be a policy which has been established by the state government. So, and so far as this petitioner contingency employees has been concerned, Your Lordship, there is no policy. There is no standing policy framed by the state for regularization.
Now, what is the difference between contingency, work charge, and casual? Apart from the phrase.
That is
Because
the issue all the time, but
whether it has not been decided by
contingency as per the dictionary is a chance employment. Is it by chance employment without any guarantee?
So by chance you are having,
Contingency means it's for a specific period.
but you are utilizing the service for last 33 years.
I'm utilizing the service, but still, the petitioner knows when he has accepted the appointment order, she knows the condition. She knows the condition of her employment, that you are contingency. Now petitioner has accepted the.
Now what is work charge?
Appointment. Now he cannot turn over and said, no, I should be regularized.
What is work charge employee?
Work charge employee.
How to differentiate whether one is contingent
Work charge
employee and
is given the name and NPWD department, Nagaland Public Works Department.
no, is there any rule or law which defines?
Work charge is covered by the Work Charge Regulation Act. There is a specific act for the work charge employees.
Okay.
So now, Your Lordship, if Your Lordship could say, or the petitioner could say, that casual employees includes contingency, in that case, that is another issue. But Lordship, in absence of any policy framed by the state for regularization, how can regularization be accorded to the petitioner?
Yes.
Lordship, you kindly see Bara 4 and 5 of the state contract. Bara 4 and 6.
Yes.
Affidavit in opposition filed on behalf of state respondent 1 to 6, Your Lordship. Para 4 and 6. May I read it? Your
Yes,
Lordship?
yes.
Para 4. That in regard to the statements made in paragraph 2 of the read petition, the answering tribunal states that the petitioner might have rendered service for 29 years and 8 months. However, on account of being a contingency employee, no regularization can be availed to him as there is no laid down provision or policy of the state government for regularization of contingency employees. Lordship, Para 6. That in regard to the statement made in paragraph 4 of the read petition, the deponent states that the OM 17/3/2015 and 22/9/2004 issued by the Personnel and Administrative Reforms Department, it speaks about the regularization of work charge employees and not as projected by the petitioner. As such, the petitioner being a contingency employee cannot seek the shelter of office memorandum dated 17/3/2015 and 22/9/2004. So now, Your Lordship, my simple submission, the stand of the state in this case, in this matter is that in the absence of any policy laid down by the state, how can the petitioner be regularized?
Okay.
Because there is no policy framed by the state for those category of employees who are full contingency, whether they are enjoying scale or whatever. So, Your Lordship, that is my humble submission before Your Lordship.
Yes, Mr. Jamir, do you want to reply?
Yes, Lordship. Just to clarify, Lordship, if I may be allowed to refer again to the Nagaland Law Journal, Lordship. 2023, Volume 1, Nagaland Law Journal, Lordship.
This one?
Yes, Lordship. Because this issue was also raised before this Honorable Court, Lordship. And the Division Bench, while deciding the matter case, Lordship, it has also clearly laid down that the contingency employees is also covered by the Office Memorandum 2015. Lordship.
Where?
Lordship, paragraph 19, page 377, Lordship. In fact, this was the core issue, Lordship, before this Honorable Court, Lordship, when the matter was taken up. Two appeals were taken up together, Lordship. Page 377, Lordship. 377, Lordship. Paragraph 19, Lordship. A conjoined reading of paragraph 19, 22, and 30 will make it very clear, Lordship.
Paragraph 19?
19, 22, and paragraph 33, Lordship.
Yes.
In this appeal, two office memorandums were discussed, Lordship. Before this 2015 was formulated, there was a policy in the year 2004 that was exclusively for workers' employees, Lordship. But when this 2015 was introduced, Lordship, it covers a variance of categories of employees, Lordship. If I may be allowed to read it, 19, Lordship.
Yes.
Now the next question therefore arises as to whether the office memorandum dated 17 March 2015 has extended the office memorandum dated 22/9/2004, even the casual contingency employees, by virtue of clause 1(3) of the said office memorandum. Clause 1(3) of the said memorandum is quoted herein below. The existing scheme for regularization of workers employees against normal vacancies being modified, and the quota of workers employees stands enhanced from 50 to 67% for the next 5 years, effective from 1/1/15. The existing scheme will also be applicable for the casual employees appointed on full-time basis. Now to paragraph 22, Lordship. A reading of the office memorandum dated 17 March 2015 would show that the object behind the office memorandum dated 17 March 15, wherein it has been mentioned that upon due consideration to the report of workers and casual employees commission and in compliance with the judgment and order of this court, the Governor of Nagaland had introduced a scheme for regularization and observation of workers and casual employees and revision of pay and wages subject to the conditions therein. Therefore, by the Office Memorandum 17 March 15, all other schemes of regularization, including the scheme of regularization of workers employees, brought into effect by the Office Memorandum dated 22/9/2004 stood affected and modified by the Office Memorandum 2015. Clause 1 of the Office Memorandum 15 stipulates how the regularization in service is to be made. A cursory glance of the clause 1 on the face of it would show that this clause relates not only to casual employees but also to all workers employees, meaning thereby the Office Memorandum dated 2004 is made subject to Office Memorandum 2015. Clause 1 Roman 1 stipulates the various conditions which needs to be fulfilled for the purpose of being regularized in respect of all existing workers and casual employees of various departments. Clause 1 Roman 1 being relevant is therefore quoted herein below. This is about the scheme, Lordship, which I've just read, Lordship. Now coming to paragraph 30, Lordship. 2015 has been discussed, and this is the final observation of this, the Honorable Division Bench, Lordship. 30, I'm reading it again, Lordship. On page 382, Lordship. On the basis of the above findings, an important issue further arises for consideration as to whether the posts which are fallen vacant in view of the setting aside of the appointments of the respondent numbers 3 and 4, the appellants in Read Appeal 6 are required to be taken into consideration for regularization of the services of petitioners. Appellants in Read Appeal 15, they are all contingency employees, Lordship. All the posts are required to be filled up in terms of the direct recruitment by NPSC. Clause 1 Roman 2 of the Office Memorandum 17 March 2015 stipulates that it is applicable to those workers and casual employees completed or will complete 30 years of continuous service after 1/1/15, meaning thereby the right of the petitioners, Read appellants will be regularized would only arise after they rented 30 years of continuous service, and at present the petitioners are yet to complete the 30 years of service, Lordship. Though it has not specifically mentioned that this is applicable, but a direction has given, Lordship, that when they complete
The
30
judgment
years,
does not specify, though it mentions about casual employees,
Lordship,
which are included in the OM of 2015.
Lordship.
It is silent as regards contingent employees. It does not whether it anywhere specifically mentions that contingent employees are also covered by OM of 2015.
Lordship,
It does not specifically mention.
it does not specifically mention, I agree.
Though your submission is that it covers.
Lordship, and an observation has been made that they are also eligible to be considered, Lordship. Lordship.
Where?
Lordship, paragraph 30, Lordship. The paragraph which I've just read, Lordship. As in when they complete 30 years, Lordship. As in when they complete 30 years.
But is whether anywhere in the judgment it is mentioned that those who are eligible to be considered after complete were actually contingent employees?
Lordship, in a similar case, Lordship, which I have just relied upon a single bench of this honorable court, Lordship, they were all appointed on contingency basis, Lordship, and they have served 34 years and 6 months, which I have just relied upon, Lordship. They were contingency employees, and the direction was given to regularize their services, Lordship. Relying on the office memorandum 2015.
No,
though admittedly, Lordship, I agree that it has not specifically mentioned that it covers even the contingency. But this office memorandum has been discussed, Lordship.
No, otherwise you could not find any judgment where it is specifically mentioned that the phrase contingent employee is included in the phrase work charge employee as or casual employees.
In fact, Lordship, clause G of the office memorandum 2015, it specifically mentions, Lordship.
What?
Only part-time, Lordship, are not covered. Otherwise, all the other categories.
Clause G.
Yes, Lordship.
The scheme shall, however, be applicable to. Not applicable.
This scheme shall, however.
No, is there any distinction between casual employee and contingent employee?
Lordship, they are more or less the same, Lordship. The nature of work, Lordship. And in fact, if I may be allowed to even refer to the definitions of dictionary, Lordship. I have relied on.
Because this is his defense. The only defense of the state government is you are not covered within the purview of OM of 2015.
Lordship, the first definition, Lordship, Nexus employment expert, Lordship. This is the definition, Lordship. Casual worker, an individual.
Yes.
May I read it, Lordship?
Yes.
Casual worker, an individual who is hired by an employer as and when the employer requires him to do work. Casual workers are often hired on an as and when need basis in industries such as retail and construction. The casual worker has limited statutory rights as there is no employment relationship with the employer. It is fundamental to the casual worker relationship that there is no mutuality of obligation. That is, the employer has no obligation to offer work and the worker has no obligation to accept the work. So that is the definition of casual worker, Lordship. Contingency workers, as defined as those who have an explicit or implicit contract for long-term employment and who hold jobs that are expected to last only for a limited period of time. So this, more or less, the definition, it has the same intent, Lordship. Persons who do not expect to continue in their jobs for personal reasons, such as retirement or return to school.
But your submission is, though the meaning of contingent worker is he is employed for a limited period of time.
Lordship.
However, if he's, in spite of being a contingent worker, if he continues for 30 years,
Lordship,
he is covered under the OM.
Lordship.
That is your submission.
Yes, Lordship. Yes, Lordship. And there is also a specific mention as to contingency as well as casual labor is also in terms of the office memorandum, Lordship. If I may be allowed to rely on the law insider, Lordship, definition and law insider, casual worker means a worker.
What is this law insider?
Lordship, this is a source, Lordship, of definition, Lordship. Or if I may be allowed to refer to Black's Law Dictionary, Lordship, the third Black's Law Dictionary.
No, I am not prohibiting you from using law insider.
Lordship.
But my query is, what is it? It is a
source where all these definitions are also given, Lordship.
Online dictionary?
Yes, Lordship, online dictionary, Lordship.
Okay.
law insider, if I may be allowed to read it, Lordship. Casual worker means a worker engaged by the hour and who may be dismissed or leave the employer's services any moment without notice and except as hereinafter provided shall not be engaged for more than 30 hours per week in alternate hours. So basically, this engagement is only for a limited period of time, Lordship. Contingency workers means the independent contractors, consultants, temporary employees, leased employees, or other servants or agents rendering services to the business and classified by a seller as other than business employees are compensated other than through wages paid by the applicable seller through its payroll department, Lordship. This is also for a limited purpose, Lordship. Third is the Black's Law Dictionary, Lordship, the definition of casual and contingency, Lordship. Casual employee. Though courts have refrained from defining casual employee, as such term is used in the Workmen's Compensation Act. The test in the particular case is whether service rendered or work done rather than contract of hiring is of casual nature, infrequency of employment or its duration being immaterial, Lordship. This is also very clear. Contingent employee, an employee who is hired for contingent work, paid by the hour or has no benefits like the regular employees. So they also...
Apart from dictionarical meaning, is there like some act was referred to? Is there any act, statute, rule or regulation where these phrases, these words are defined? There is a contingent
there is an act, Lordship, state government, Lordship.
It does not define.
Lordship, it is being defined, Lordship. Yes, Lordship. Paragraph 16 of the judgment which I have relied upon. There is an act, Lordship, in the state of Nagaland, Nagaland Work Church and Casual Employees Regulation Act 2001, Lordship. But it has defined only work church and casual, Lordship. Contingency has not been defined in this act, Lordship.
No, how casual workers are defined?
Lordship, paragraph 16. May I read it, Lordship? Lordship,
no, we may see that whether is irrespective of nomenclature used while appointing you,
Lordship,
you were appointed as a contingent employee.
Lordship.
But whether the nature of work
is the same, Lordship.
Whether you also fall within the definition of casual worker or contingent or work charge worker used in that.
The nature of work is similar to those work church employees as well as casual employees, Lordship. No definition is not, the term contingency is not defined, Lordship. The nature of work, all this falls under the category of temporary, Lordship. In fact, the case of Jagjit Singh, Lordship, 2017, volume 1, Lordship. Jagjit Singh, page 148, Lordship. It is clearly stated about temporary employees, Lordship. Temporary employees, Lordship. I don't remember the 2017, volume 1, SCC, page 148, Lordship.
Okay.
It is defined, Lordship. In this case, temporary employees. These are the categories of temporary employees, Lordship. And it falls that temporary employees includes work church, casual, contingency, contract, and ad hoc employees. And the like nature, it is specifically mentioned, Lordship. And the like nature, Lordship.
Okay.
Therefore, Lordship, my humble submission before this honorable court. My appointment is a temporary appointment, Lordship. I was specifically appointed as a contingency employee, Lordship.
Heard Mr. Moa Zamir, learned counsel for the petitioner. Also heard Mr. Moa M. Chen, learned senior government counsel, appearing for all state respondent. Hearing concluded, judgment reserved.
Much obliged.
Give this file to me later.
For hearing, Item number 35.
Mazui. Who is for respondents?
State respondent. State council is not here.
What is the matter?
Lordship, this matter relates to replacement of a village council member, the petitioner, by a different person.
Okay.
Village Council Acts is very clear, Section 4. A village council member will be selected or elected by the villagers in accordance with the customary practices. Now, I've been selected by my clan, by my villager.
Which village?
Koyo village.
Because yesterday I heard a similar matter
Lordship.
relating to Lakhuti village. So issues may be similar, perhaps may be similar in this case.
Lordship.
So, yes, what are the facts? You were selected.
I was selected.
Then?
And some vested person has put up a name before the government, and I was replaced by the government. There is no provision under the Act for replacement. I can be either disqualified or I can be removed as per the Village Council Act. But I have been replaced by the government lordship. At the government level, my name has been duly selected, sent to the government, approved. But somebody lodged a complaint.
No, who selected you? The clan members.
Yeah, the clan members. Lordship.
Thereafter, some scrutiny was also done.
No, Lordship.
No.
Normally, as per the Act, Lordship, the Act provides that village council members, VCM, will be selected and elected by the villagers. So normally, in normal practice, a person is selected to represent the clan. His name is forwarded to the government approves it.
No, I am not getting it. Who, in place of villagers, who select the VCM? Who votes?
The villagers.
Villagers vote.
Yes.
Another similar case, there were KHEL members.
Yes. It's either by the KHEL or the clan members or KHEL.
Okay. No, they themselves vote or they authorize the.
No, they vote. They select.
Okay.
They nominate. That so will represent our clan.
Each clan selects their own representative.
That's the procedure.
Okay, Mr. Zimomi, you are appearing in this case. Then let us hear. Yes.
So here, in my case, Lordship, I was selected by my clan members. My name was forwarded to the government, Lordship. Government approved my name. My name was approved.
Government approved?
Yes.
Thereafter.
Lordship, if I may be allowed to read Section 4 of the Village Council Act, Lordship.
Yes.
Lordship, Nagaland Court, Volume 3.
Yes, a village council.
Second edition.
No, it is there in this book also.
Yes, it's yes, Lordship. So Section 4, Lordship, I may be allowed to read Section 4.
Yes.
A village council shall consist of members. Lordship, if I'm referring to the same edition, it's second edition, Lordship.
Okay.
Page 62. Yes. Section 4, Lordship.
Yes.
A village council shall consist of members chosen by villagers in accordance with the prevailing customary practices and usages, the same being approved by the state government. The law, the proviso part doesn't concern me, Lordship.
Okay.
So I will be selected by the villagers, Lordship, by my clan or by the KEL, my name will be forwarded to the government. Government will approve it. The section 4 is very clear, Lordship. It reads, the same being approved by the state government.
Okay.
My selection. So in my case, Lordship, I was selected by my clan. My name was forwarded to the government. Government has approved my name as VCM for the tenure to 2021 to 2026. Very interestingly, Lordship, some vested person has lodged a complaint to the government. I also am not aware. I was not aware. And then government has replaced me.
Lodged a complaint regarding the selection procedure?
No.
Then? That you are
Then
otherwise...
I should be replaced.
No, what was the complaint?
Lordship, you can kindly turn to Lordship, you can come to page 35 of my repetition, annexure F. This is my clarification, Lordship.
Clarification?
With regarding to my selection.
Clarification in response to what? Why you...
Because I got information that a move was made to replace me.
Okay, somebody has lodged a complaint against you.
Yes, which I'm not aware.
Okay.
So I have written a clarification to the Deputy Commissioner, Gauhati District, Lordship. I will allowed to read, Lordship.
Yes.
Clarification with regard to selection election of VCM Koyo Village. Sir, with due respect and humble submission, I beg to state that as per the information of the head GB Koyo Village, Okanagan, for submission of elected VCM from every clan, we the Chuchuri Kikon clan of Koyo Village had discussed the matter at land and after approval from majority of the clan members had elected Sri Info Kikon. That is me, Lordship, of Koyo Village as VCM from Chuchuri Kikon clan of Koyo Village and submitted the list to the head GB Koyo Village, copy enclosed. And thereby it was subsequently approved by the Extradition Commissioner EAC Chukunang Wokha Nagaland and then the Deputy Commissioner DC Wokha Nagaland. The selection of Sri Info Kikon is done democratically by majority of clan members without any bias, and there was no claim and objection from anyone till the date of the Deputy Commissioner limited the time for entertainment of complaint. However, it is learned from the reliable source that a complaint was submitted recently to the Deputy Commissioner Kohima, Okanagan, by some vested person to replace Sri Info Kikon as VCM Chuchuri Kikon clan by Sri Hatungo Kikon, which is not in the interest of the clan members. Besides that, Sri Hatungo Kikon, the private respondent, Lordship, is a resident of Chikudong village and not of Koyo village and do not have the support of the Chuchuri Kikon clan of Koyo village. But their sole purpose was to disturb the VCC election of Koyo village. Therefore, I request your esteemed authority to not entertain any complaint as selection of Sri Info Kikon was done in a free and fair manner and by the majority of the people of the Chuchuri Kikon clan of Koyo village. And for me, at the finance, so. And then I have I've given this clarification. Now, thereafter, Lordship, Annexure G, page 36, Lordship.
Yes.
This letter dated 2nd August 2021 to the Commissioner, Nagaland Kohima, approval for replacement of VCM in respect of Koyo village under Wokha district. I am directed to refer to your letter number so-and-so, dated so-and-so, 22/7/2021 on the subject cited above, and to convey the approval of government for replacement of VCM in respect of Koyo village under Wokha district, as stated below. Sri Hatungo Kikon in place of Sri Info Kikon. So I was replaced by the private respondent without assigning any reason. Lordship, I really appreciate that fact of the matter. They have to give a reason why I am being replaced. No reason was assigned in this letter. Now, Lordship, if I may be allowed to take your Lordship to the Nagaland Village Council Act. Section 9.
reasons were not mentioned in the order.
Lordship,
No, where reasons were not mentioned?
no reason has been stated in the letter.
Letter, okay.
They're just giving the approval for replacement. No reason given, Lordship. Lordship, take an example, I'm holding a post. I'm holding a post. To terminate me, Lordship.
No, but who mooted this replacement?
Some vessel person which I don't know, from the government level. Now, Lordship, if I may allow to take your Lordship to the provision of the Act, how a member can be removed.
Yes.
Section 9.
Yes.
Power to remove members.
No, but it is applicable to the members who are holding a post of VCM.
Yes, I'm holding the post of VCM. Lordship, my name was approved. Lordship, I take your Lordship attention to that. Lordship, may kindly come to page 31, Annexure E.
No.
This is the government approval of the writ petition, page.
But whether you were appointed as VCM, appointment was not done.
No, Lordship, once government approve, they don't issue appointment orders, which my learned friend also will not dispute to that fact, Lordship.
Okay.
No appointment orders are issued. This is the approval of the government. Lordship,
So once you are
taking your Lordship attention to section 4.
Okay, once you are approved, your name is approved.
As a VCM.
Who forwards the name? Gambura.
The Gambura will forward the name to the Deputy Commissioner.
Okay.
Deputy Commissioner will forward it to the government. Government approves.
And as soon as government approves,
I automatically become the
you
VCM.
becomes a
VCM.
member of
Yes,
village council.
Yes. Section 4 is very clear, Lordship.
And thereafter,
To
according
remove
to section 9 would have to be taken recourse
Yes.
to.
Had it been under the provision of section 9, they should have quoted, in excess of the power under section 9, I should have been removed, Lordship. Lordship, my name appears at, Lordship, may kindly come to page 34 of the writ petition. This is, page 31 is the approval letter, Lordship, in respect of Gauhati district. This is 10 June 2021. Lordship has found page 31 of the writ petition.
Yes.
This is 10 June. I may be allowed to read, Lordship. To the Deputy Commissioner Wokha. Approval for the newly elected selected village council member in respect of Gauhati district regarding serial number 130 in the chart, Lordship, Kohima village, where I'm concerned, my village. Serial number 130. Lordship has found?
Yes.
Then Lordship may kindly come to the page 34. Since it involved a big number of villages, I have just extracted my village concern, Lordship. Page 34, number 5, Kohima village, Lordship. Lordship has found?
Yes.
My name appears as serial number 6. Mfo Kikon.
So approval was
given by the government.
Given to this list.
Yes, as per section 4.
On 10th of June 2021.
Yes. So I have officially become a VCM.
Okay.
Now to remove me, Lordship. Section 9. Power to remove members. Lordship, I mean, to read, Lordship.
Yes.
Section 9. The state government may remove any member of a village council from his office. Government has got a power, Lordship. But there are conditions. A. Who is convicted of an offence involving moral turpitude by a court of law. B. Who refuses to act or become incapable of acting. Or C. Who is declared to be insolvent. Or D. Who has been declared by notification in the Gazette to be disqualified from employment in public service. Or E. Who, without any excuse or sufficient ground in the opinion of the state government, absent himself from the majority of the meeting in a year of village council. Or F. Who has been guilty of misconduct in discharge of his duties or of any disgraceful conduct, and 2/3 of the total number of the village council at the meeting recommend his removal. So, This is the provision where I can be removed or replaced, Lordship. Nowhere in the Act talk about replacement. I can be removed. Then government can direct for again re-election, or nomination or selection or election.
Yes.
Lordship, I may be not to take your Lordship attention to section 16 again, page 66. This is disqualification. There are only two grounds where a member can be removed. Under sections 9 and 16. 16 speaks about disqualification. Section 16, I may be allowed to read the Lordship.
Yes.
A person shall be disqualified from being selected as and for being a member of the village council. 1. If he is unsound mind and stands so declared by the competent court or such authority as may be recognized by the state government, or B. 2. If he is a citizen of India, has been voluntarily acquired citizenship of foreign nation, or is under acknowledgement of allegiance to a foreign nation, or 3. If he has been convicted by a court in India for an offense and sentenced to imprisonment for not less than 2 years, unless a period of 5 years or such less period as the state government may allow in any particular case has elapsed since his release, or number 4, if having held an office under any council he has been found guilty of corruption, disloyalty or breach of such council laws, unless a period of 5 years or such less period as the state government may determine in any particular case has elapsed since his becoming so disqualified, or 5, if he is undischarged insolvent, or 6, if he is a salaried government servant or employee of an area council, or 7, if he abstained himself from the majority of the meeting in a year and is unable to explain such absence to the satisfaction of the council, or if he is a member of any other village council, or if he has been dismissed from the service of the government of any other local authority for misconduct unless a period of 5 years has elapsed from the day of dismissal.
So in your case, there is no case of dismissal also?
No, it was not a case of dismissal. I was just replaced.
Okay.
Now, Lordship, very interestingly,
We'll continue
Lordship.
at 2. Yes, Mr. Musa.
Yes, Lordship. Now, Lordship, as I've already stated, for replacement, there is no provision under the Act. I can either be removed
or
of
disqualification
the following grounds under Section 9, or I can be disqualified
under Section 16.
So there is no ground for replacement, Lordship, as per the Act. And while issuing the impugn letter, Lordship, Annexure G, page 36.
No, replacement, whether the replacement was the name, the person whose name has been replaced, or who has replaced you.
Yes, Lord.
Whether it was also forwarded by the villagers.
No. It was done in the government level.
Without following the...
Yes. Because, Lordship, going back to Section 4, any election has to be done by the villagers, Lordship. Now, Lordship, coming to the facts of the case.
What happens if someone... What was the allegation against you? You don't know.
Nothing was told to me, Lordship. I was not informed. I was not given any opportunity to explain why I should be replaced.
Now, government has also not mentioned in its affidavit.
No, they are totally silent.
What was the allegation against you?
Lordship, that's why I was taking your Lordship's attention to Annexure G, page 36. It was just a letter.
Okay.
Saying that the government has given this approval for replacement.
But government can give approval to only to a list which is forwarded to them by the villagers.
Yes,
villagers.
By the head Gambura.
Gambura.
Yes.
So to what they have approved, given their approval, unless there is a proposal from the villagers through Gambura.
Yes, Lordship. Now, Lordship, coming to the facts of the case, how I was settled, Lordship. Now, based on the direction of the government for the tenure 2021 to 26, the Deputy Commissioner has directed the head GB to conduct the selection election as per Section 4.
Okay.
Now, Lordship will kindly come to page 22. This is the order. Page 22, page 21 Annexure B, but 22 is the type of Lordship.
Yes.
This is order dated 9 March 2021. In pursuance to the Deputy Commissioner Office notification number so-and-so dated 8 March 2021, it is hereby informed to all the villages under Sadra that the existing village council stands dissolved with effect from 10 March 2021, and the head GB shall resume charge of the village administration till the constitution of the new village council. In this regard, it is hereby notified to all the recognized village under Wukha district, Wukha Sadra, to elect new village council member for the next tenure as per the prevailing customary practices and usages, and in accordance with the Nagaland Village and Tribal Council Rules 1979 and the Nagaland and Village Council, Nagaland and the Tribal Council Act 1978. It is to be mentioned that the whole process of the election of the village council members should be completed on or before 25th March 2021, and the list is of the new village council members may be submitted to SDO Civil Sadar for strict compliance. Now, this order was issued to the head GB. Copy to serial number 3, head GB, to all the villages, Lordship. Now, my clan is the Chuchuri Kikon clan, Lordship. The clan members, my clan, have selected me. And this Annexure C, page 23, Lordship. Type copy is, translated copy is at page 24, Lordship. Translated copy, page 24. To the head Gambura, Lordship as well. Koyo Village Council, Wukha Nagaland. We, the Koyo Chuchuri clan, request you to acknowledge our clan's decision that as per the GB's order dated 14/3/2021, we, the clan members, unanimously elect Shri Info Kikon as our clan VCM member. We therefore request you to kindly accept our decision.
But it is signed by only one person.
Site, yes. Lordship, Annexure C signed by two persons, the secretary and the chairman of the clan.
Okay.
I'll supplement this letter also, Lordship. There's a document also. So page 25, Lordship, is a form given by the village council, by the HGB. So self-declaration form for village council member 2021. The candidate has to, the selected member has to give his declaration. I, Sri Info Kikon, permanent resident of Koyo village and elected select basin of Koyo village, hereby declare that I am not salaried government servant and not a member of any other village council, and the information provided above is true and correct, and I fully understand the consequences of giving false information. Signed by the petitioner Lordship on the right hand side and accepted by the HGB, who is the authority now. Because after the dissolving of the village council, the HGB becomes the authority till the new VCM comes. Now, Annexure D, page 26. Lordship, this is the local dialect Lordship. Lordship, I may be allowed to read from page 29, the translated copy. This is how I was selected, Lordship.
Okay, they voted for you.
Yes. We the house taxpayer of the Chochuri Kikon clan have unanimously selected Sri Info Kikon as VCM of Koyo village for the tenure 2021 to 2026. The following names and house number signature are given below. So 44 members of the clan have nominated me, selected me, Lordship.
Okay.
And after accepting by the HGB, he has forwarded to the government. And Annexure E, page 31, Lordship, I have already referred to the approval of the government. My name was approved. And that is in accordance with the section 4.
So your submission is on being approved.
Yes.
You become a village council member.
Yes.
And
They don't issue any appointment order.
And you can be removed only as
per section 9
or 16.
I can be either be removed on various grounds or disqualified under the various grounds. Now, they have not stated any reason why removing me, Lordship.
Okay.
Because if I have to remove, I should fall under the provision of section 9. There are altogether 6 grounds how I can be removed, Lordship. For disqualification, there are 11 grounds where I can be disqualified.
Now, in this writ petition, what you have challenged?
I have challenged the Annexure G.
At page?
Page 36.
The replacement?
Yes, where I was replaced.
Okay.
My whole grievance is here, Lordship. Annexure G. Page 36. Without assigning any reason, I was removed. I was replaced. So, Lordship, the language is very important, Lordship. It's not replaced or disqualified. Removed or disqualified. I was replaced. The Act does not provide any reason that I can be replaced. And no communication was given to me.
Before replacement, there has to be either removal or disqualification.
Disqualification, yes. Then only I can be replaced. Okay. So I was citing an example, Lordship. I'm holding a post. I should either be terminated because somebody cannot just come and replace me, Lordship. I have to be terminated so that somebody will come and join the post, Lordship.
Okay.
So basically, my case is that, Lordship. Now, as far as the private respondent is concerned, Lordship, I have made certain allegations against the private respondent that he is from another village, which he has justified to that aspect of the matter. But my contention here is, under the provision of the Act, the question of replacement does not arise.
He is not from this clan.
No, he is not from the clan.
Whether a person outside the clan may be selected.
That is the issue. He was residing, these forefathers were residing in the village. They have shifted to another place.
Okay.
Now, Lordship, even assuming that, okay, he can be appointed in the village, but not admitting the fact, even assuming, but not admitting the fact that he can be appointed. He has to go through the selection process. Section 4. Whether he has gone through the process, that is the issue, Lordship. Yes, the representation was submitted to the government by the petitioner, along with the other clan members, against the private respondent that he's from another village. And then at one point of time, their forefather was residing in the village, but they have shifted. Those allegations has been made, Lordship. But the main ground here is whether the Provisional Act has been followed by the government in removing me or disqualifying me. Not done, Lordship.
Okay.
That is my case, Lordship, in a nutshell.
Any authority, any
No,
ruling?
Lordship, as far as this case, it's a one of a kind case, Lordship. It's a very peculiar case, Lordship.
Okay.
Very peculiar, because it's either disqualified or removed. Because this case has happened, Lordship, I should say it's one of a kind. Because Lordship was holding a book before, that written by retired Justice Zangre Z. Angami. Now, under that book also, Lordship, though so many citations has been made, it's regarding disqualification or removal. No instance has happened as far as replacement is concerned. It's one of a kind, Lordship. It's a unique case.
Okay.
That's my submission, Lordship.
Yes, Mr. Zimomi.
May I please, the Lordship? Lordship, here I am for the respondent number 1, 2, 3, and 4, Lordship. And the state has filed affidavit on 26 April 2023, Lordship. And the state, in our affidavit in opposition, Lordship, I am relying on paragraph 3, 5, and 6, Lordship, of my affidavit, Lordship.
Yes.
Lordship, may kindly come to my affidavit in opposition filed by respondent 1, 2, 3, and 4. More particularly, paragraph 3, Lordship. Paragraph 3 of my affidavit, of the state affidavit.
Yes.
If I may allow, Lordship, I am allowed to read paragraph 3, Lordship.
Yes.
Paragraph 3, that with regard to the paragraph 1, 2, 3, so and so of the petition is extend borne out of record. However, the deponent begs to state that as per the Village Council Act 1978, which clearly states that a village council shall consist of members chosen by villagers in accordance with the prevailing customary practices and usages. The same, next page, the same been approved by the state government, provided that hereditary village chief, GBs, and arms shall be the ex-official members of such council and shall have voting right.
What is ANGS?
Lordship, especially in Connect area, Lordship, we have
We have different, they have kingship, Lordship.
Kingship,
Ang is a king.
He's head of the
They
family.
have a kingship system, Lordship.
Okay.
Eastern Nagas.
But it particularly relates to the Konyak tribe.
Okay.
Of Mon district.
Yes, proceed.
Therefore, as per the Village Council Act 1978, the matter was forwarded for government approval to the Home Department letter number so and so dated 5/3/2021 and directed to issue notification as per the Rule 3 of the Nagaland Village and Council Area Council Rules 1979 in accordance with the Nagaland Village and Tribal Council Act 1978 for selection of new village council members for the next tenure, whereby the deponent has forwarded to all the district deputy commissioners as per the letter number so and so, which is dated 5/3/2021, which is annexure A of the writ petition. It is to state herein that the Deputy Commissioner Worker, by letter dated 9 March 2021, annexure B of the writ petition, has issued an order to all the village council members to complete the whole process of selection election of the village council member to be completed on or before 25th March 2021, and the list of the new village council members to be submitted to SDO Civil Sada for strict compliance. Furthermore, the Chichuri Wapong Clan member unanimously elect Sri Nipu Kikong as the VC member. That is the
Present petitioner.
Yes, Lordship.
Okay.
So, Lordship, next page, Lordship. The deponent further begs to state that this is the fact, Lordship. The deponent further begs to state that by letter dated 10 June 2021, the approval for newly elected selected village council members in respect of Waka district were issued, wherein the petitioner name for the selected elected of VCMs of the village was placed at serial number 6, annexure E of the writ petition. However, it is pretending to state herein that from the office of the Deputy Commissioner, very important, Lordship, now, from the office of the Deputy Commissioner Worker, no objection certificate was received from the head GP, Koyo village, by submitting no objection for selection of VCM to represent the clan by Sri Hatungo Kikong, now the respondent number 5 in the present instant case, Lordship, along with a copy of meeting resolution dated 16/6/2009, endorsed by 29 members of the Kikon Chichuri clans of Koyo village, stating unanimously approval of VCM member to Sri Hatungo Kikong, respondent number 5, in place of Sri Nifyo Kikong, the present petitioner. Therefore, as per the power vested under Section 4 and Section 20 of the Village Council Act 1978, the matter was forwarded to the higher authority to take necessary action. Accordingly, by impugn letter dated 2/8/2021, annexure G of the writ petition, the Deputy Secretary to the Government of Nagaland, Home Department General Administration Branch 1, issued an approval for replacement of VCM in respect of Koyo village under Woka district to Sri Hotungo Kikon in place of Sri Nifo Kikon as the village council member, Lordship. Next page, Lordship. It is therefore pretending to state herein that no illegality or infirmity has been committed by the respondent authorities. The authorities, after careful consideration and more importantly, after receiving of no objection and various letters from the concerned Koyo village, the approval dated 2nd August 2021 was issued in favor of Sri Hotungo Kikon in place of Sri Nifo Kikon. Moreover, from the conjoined reading of the Section 4 and Section 20 of the Nagaland Village Council Act 1978, more particularly Section 20, inter alia states as follows. When a dispute arises as to the selection of any member of a village council, the matter shall be referred to the state government, whose decision thereof shall be final. The state government, in all fairness, transparency, and after careful consideration, approves Sri Otungo Kikon, for which the action of the respondent is in conformity with the Section 4 and Section 20 of the Village Council Act 1978, Lordship. Lordship may kindly come to the Section 20 of the Village Council Act, Lordship, 1978. The Nagaland Court, Volume 3, page 67, Lordship, 67. Section 20, if I may know, Lordship.
Yes.
It states that when a dispute arises as to the selection of any member of village council, the matter shall be referred to the state government, whose decision thereon shall be final, Lordship. So now here, Lordship, here the matter pertains to the election of the village council member. Earlier, the petitioner name was proposed for selection to be the village council member. However, Lordship, however, after his name was proposed, Lordship, the head GP of the Kohima village has submitted a no objection certificate for replacement of the petitioner by respondent number 6, Lordship. Lordship, which you Lordship will find in annexure A of my affidavit in opposition. Lordship, you may kindly come to annexure A. Annexure A, which is at page 11, Lordship. If I may allow, Lordship. Page 11.
Yes.
To the Deputy Commissioner, Wakhan Nagaland, subject no objection. Sir, with due respect, I have the honor to forward herewith a resolution submitted by Chuchuri Kikon clan, Koyo village, for selection of VCM to represent the clan by Hotungo Kikon. This is for your further necessary action, please. Forwarded by Ikong Nule Head GP Koyo village. And Lordship may kindly come to page 13, Lordship. 13 is a translated copy, Lordship.
Yes.
If I may, Lordship. To the head GB, Koyo village, Woka Nagaland. Respected sir, with due respect on behalf of the family of Chichuri Kikon clan, Koyo village, we would like to bring to your notice that Sri Nifo Kikon was elected as VCM member from Chichuri clan. However, he was made to resign. Very important, Lordship. However, he was made to resign from the VCM in accordance with the clan's resolution number 1 on 16 June 2009 due to his failure to obey and adhere to the clan and family's resolution. The Chichuri clan elected Sri Hatungo Kikon as VCM as a replacement to Sri Nifo Kikon. Therefore, we requested you to kindly accept this clan letter of endorsement and proposal, Lordship.
No, but whether he has resigned before you took a resolution?
Lordship, no. However, Lordship, here, Lordship, the village council, I will come to that, Lordship.
Two queries. One, whether he has resigned. Thereafter, another query is, once government has approved the name of the present petitioner, whether without following section 9 or section 16, a parallel process may be initiated for substituting the...
Yes, Lordship has rightly pointed out, Lordship, we have complied with the section 9 also, Lordship. Lordship, here it says power to remove members, section 9, which says power to remove members. But here it also says that, more particularly, 9(1)(b), page 63, Lordship. Section 9(1)(b), which says that who refuse to act or become incapable of acting or.
What it means.
Now, what happened, my lord, see, they have made a resolution. And moreover, Lordship, section 4, which says that a village council shall consist of members chosen by villagers in accordance with the prevailing customary practices and usage. The same being approved by the state government, provided that the hereditary village chief, GPs, and aunt shall be ex-official members of such council and shall have a voting right, Lordship. So, as per the customary practices and usage, Lordship, the clan member, they select who to be a VCM, Lordship. So they have made a resolution, Lordship. And in that resolution also, Lordship, may kindly come to page 17, Lordship. Page 17, translated copy. Which is in consonant with the section 4 of the Village Council Act 1978.
What is 17?
Page 17.
What it says?
1. The election selection of VDP member and VCM member are to be done in accordance to the will of the Chichuri clan. However, if the member goes against the will of the clan and act according to his own will, the clan will make him to resign and a new member will be elected as a replacement. So this is according to this resolution, Lordship. Now the petitioner
But
has
this
been placed-
resolution appears to be contrary to the act.
No, Lordship, section 4, which says that a village council
Section 4, to what I have understood till now, limited to selection of village council members by the villagers. They may select him as per the prevailing customs.
Lordship.
Once they select a person,
Yes.
it has to be approved by government.
Yes,
And
Lord.
once government approves him, the villagers have no other role. Then how he would be disqualified, how he would be removed, the acts take care of that. Otherwise, it would be a continuous process. The villagers may again change a resolution. The selection of a new member has to be according to some law. You are quoting section 4, that section 4 empowers you to replace an earlier selected member also.
Yes,
Is
Lord.
that your submission?
Yes, Lordship. So, which is in consonance with section 4 of the Village Council Act 1978, Lordship. That is my submission, Lordship. See, Lordship, here in this case, what happened was, earlier the petitioner's name was selected. But as per the resolution made on
He refused to follow
2009, Lordship.
the allegation against him that he has gone against the will of the clan.
Yes, Lordship. And accordingly, it was duly signed by the chairman as well as the secretary of the Koyo village. And moreover, 29 of the members of the particular Koyo clan, particular Chichuri clan, they have appended the signature. So, which shows that the authenticity in this resolution, Lordship. So, Lordship, what the Lordship is well aware and Lordship may appreciate. Yes, the selection will be done from the village, Lordship. And that has to be approved by the chairman or by the head GP, who has the voting right. So accordingly, as per the resolution, since the petitioner did not abide to the resolution that was made on 16 June 2009, now the villagers, they have proposed the name of the respondent number 6. And since the matter reached no objection was submitted by the villagers, and then it submitted to the deputy commissioner, the matter was forwarded to the government, Lordship. And accordingly, government has approved the name of the respondent number 6, which is in consonance with section 20 of the Village Council Act, Lordship. So, Lordship, when...
No, section 20 will be applicable if a dispute arises. Section 20 will be applicable if a dispute arises regarding selection of a member in event of falling of a casual vacancy.
That is during the selection time, Lordship. That is during the selection time. But my case is I've already been approved. I'll come to that.
Yes, Mr. Zimawi, continue. These are my queries only. I am not giving my opinion. Continue.
Lordship may kindly come to paragraph 5, this page 6
of
my affidavit, Lordship. If I may, Lordship.
Yes.
That with regard to the statement so and so of the writ petition, the deponent admits the same to the extent borne by the report. However, the deponent begs to state that since no objection and various letters was forwarded by the Koyo village to the undersigning authority, stating unanimous approval of VCM member to Sri Hotungo Kikon in place of Sri Info Kikon, the deponent, by invoking Section 4 and Section 20 of the Nagaland Village Council Act 1978, it is also to state herein that Section 4, which stipulates that a village council shall consist of members chosen by villagers in accordance with the prevailing customary practices and usage, which was duly approved by the state government, wherein it is also mentioned that the chief, village chief, GBs, and ANG shall be the ex-official members of such council and shall have voting right. In the instant case, the state respondents authorities have acted in conformity with the Village Council Act 1978, wherein the head GB of the Koyo village has forwarded no objection to the Deputy Commissioner Woka, and so also the Chichuri Clan's resolution dated 16 June 2019, unanimously elected Select Sri Hotungo Kikon as VCM of Koyo village. It is also important to state herein that the approval dated 22nd August 2021 for the placement of Sri Hotungo Kikon in place of Sri Info Kikon was issued only after receiving of no objection and several letters from the undersigning authorities. More so that one, namely Mericom Kikon, who is the present chairman, and Sri Kondemo Kikon, secretary of Chichuri clans of Koyo village, has forwarded the matter to the head GB's Koyo village. Woka clearly stated that even though Sri Info Kikon was elected as VCM for their clan, however, he was made to resign. However, more important, Lordship, he was made to resign from VCM in accordance with the Clan Resolution number 1 of 16 June 2009 due to his failure to obey and adhere to the clan and family resolution. Therefore,
one moment, please.
Yes.
Mr. Zimami, resignation has to be given by the person concerned, or whether the villagers can by adoption of a resolution by the villagers, it would amount to his resignation.
Lordship.
Two queries. For resignation, whether the person who is resigning has to act, or whether merely by adoption of a resolution by the village council villagers, would it amount to resignation of the already selected member?
Yes, Lordship. Yes.
My query is clear that for whether the resolution is that he has been made to resign, whether actually petitioner resigned or not, that is a query.
No, actually he has not resigned, Lordship. He has not resigned. However, Lordship, Section 4 which says that it should be chosen by the villagers, Lordship. See, Lordship. Here, Section 4, it says that
no, you have already
has to be chosen by the villagers in accordance with the prevailing customary practices and usage, Lordship. So, Lordship, what happened was it is between the clan, Lordship. It's not a village as a whole, but it is a clan who decide whom to be the VCM, Lordship, amongst the clan, Lordship. So the clan, they have made a resolution, Lordship.
Is there any prevailing custom or practice of replacement of VCM after he has been selected?
Lordship, this
Well-
is normally, this is what the practice, Lordship. Normally what they do is, the clan, they used to make a resolution, and within that resolution,
No,
Lordship,
if it is a customary practice and
Lordship, that is the practice, Lordship.
then you have to show that earlier also we replaced so-and-so VCM members by adopting a resolution. Then your plea that there is a customary practice of changing replacement.
Actually, Lordship, since Lordship is well aware regarding the Section 4, Lordship, since the matter has been forwarded by the village head GP and the chairman of that particular clan of the Koyo village, who submitted the no objection, and they have proposed the name of the respondent number 6, Lordship.
No,
So
that I have I am just trying to understand your submission. That suppose now respondent number 5, after some time you lose faith on him, then you have replaced the petitioner by respondent number 5. The tenure is of 5 years.
Lordship.
Now in between, suppose you don't like respondent number 5, can we, without taking recourse to section 9 or section 16, you can again send a proposal, sending a replacement for the respondent number 5. Can that be done? My query only.
Lordship.
Whether that is permissible under section 4. What is your reply?
Yeah. Lordship. Actually, the rule is silent on that, Lordship. So,
That is a good answer. Actually,
Yes.
rule is silent.
Yes, Lordship.
So it may be done, it may not be done. That is
Yes,
your
Lord.
answer.
Yes, yes.
Okay.
To that extent, Lordship. Since the act itself is silent on that. But however, Lordship, as far as the state respondent is concerned, Lordship, since the matter has been received from the village concerned, Lordship.
Your submission, as I understand,
Lordship.
is that you exercised your powers under Rule 20, Section
Lordship,
20,
Lordship.
that a dispute was there, and therefore you decided,
Lordship.
and now your decision would be final. Is that your submission?
That is our submission, Lordship. And moreover, in fact, Lordship, in our affidavit also, we have clearly stated that on this Honorable Court by order dated 21/11/2021.
Where are you reading?
Lordship, page 8, Lordship. Page 8. Page
Yes.
8, paragraph 2, Lordship.
Yes.
Here also, Lordship, if I may allow, Lordship. It is further to state herein that, as directed and in compliance to the Honorable Court order dated 21/11/2021, Mr. Nifo Kikon, the present petitioner of Koyo village, shall function as village council member, and the approval of Mr.
You are under interim protection.
Still protection, Lordship.
I'm
And then,
functioning as a VCA.
Lordship, page 22, Lordship, Annexure E. Annexure E of my affidavit, Lordship.
Yes, annexure as
Yes, Lordship. Annexure E of my affidavit.
yes.
In partial modification of this office order, even so and so dated 1st September 2021, and as per the Honorable Court High Court judgment order dated 2/11/2021, Mr. Nifo Kikon of Koyo village shall function as a village council member, and the approval of Mr. Hotungo Kikon as village council member by approval
It is
so and so
kept
issued
in abeyance.
from the Home Department shall remain suspended till further order, Lordship.
Okay.
So, Lordship, as far as the state respondent is concerned, Lordship, there is no illegality or infirmity committed by the state respondent till such time, Lordship. And we are complying with the honorable court's order, Lordship.
Okay.
And Lordship, more so I'm relying on Section 4 and Section 20 of the Village Council Act 1978, Lordship. Since, Lordship, as far as the state respondent is concerned, Lordship, once we receive any objection letter or whatnot, Lordship, once we receive, we send it to the government, Lordship. So, as per the Section 4 and Section 20, we have forwarded the matter to the government, and the government has approved, which is under challenge at this instant case, Lordship.
Okay. Yes, Mr. Pongena.
If I may be allowed to counter a small reply to the state submission, Lordship, just for a clarification.
Okay, but it would be good if you reply after hearing both of them.
Lord, I'm okay with that.
Because you may have to reply him also.
Yeah.
So may it please your Lordship, if your Lordship may go through the entire writ petition, there are two main grounds. One is that the petitioner was selected in terms of Section 4 of the Act by the clan in accordance with the prevalent practices. That is one case, and his name was forwarded. The second point which he is stressing about is that some unknown persons, some illegal vested interested, some unknown person, paragraph 24 sums it up. Some vested person had attempted to replace the petitioner. That he does not know who these vested persons are. They have sent for his replacement. That is his second case. The third point is with regard to the petitioners, the respondent, the present respondent whom I'm representing is from the village or not. He has put much stress on the fact that I am not a part of I am not a villager. I have migrated already. I am no longer a member of the village, so I am not eligible to be appointed. So those are the only three grounds. If your Lordship may go through the petition. Now this is with regard to election, your Lordship. Yes, initially the petitioner was elected by the clan itself in terms of the settled customary practices.
No, you have not taken those grounds of Section 9 and Section 16.
No.
In the writ petition.
No.
Lordship, though I have not expressed in the petition, it's implied.
It is law.
It is a law. I don't have to interpret the law in my petition, Lordship.
Otherwise, you have not specifically mentioned.
No. But what I'm saying is, I cannot be replaced. My ground is that.
You have stated some.
Yes.
I cannot be replaced. That is my stand.
Okay.
Because on the question of law, the provision of the Act.
Okay, that need not to be pleaded.
But whatever
specifically.
Those are the main grounds on which he has stressed. So I have made specific answers to it, and then he has suppressed material fact. My ground is that the petition is liable to be dismissed for suppression of material facts in the case. That is one main point which I am going to raise subsequently. Now, Lordship, instead of me trying to orally go through all the facts, I'll take your Lordship to the specific paragraphs.
Yes.
In my, then after that I'll go to the annexures, Your Lordship. Starting from paragraph 4, Your Lordship.
Of your
Of my
affidavit.
Yes, affidavit in opposition. Paragraph 4. Affidavit in opposition, respondent number 5. Your Lordship. Filed on behalf of
Just a
respondent
minute.
number 5.
Yes.
If I may read, Your Worship, I'll try to read it as slowly as possible. That with regard to the statement made in paragraph 3 of the petition, the petitioner respectfully states that the Goyo village has adopted a resolution dated 19/10/2017, which is an extension of earlier similar resolutions as is reflected in the introduction of the resolution itself, which provides in resolution number 6b that Goyo village people residing outside the village will also be included while forming village council, and that 2 representatives each from Kohima, Goyo Ikong, Woka Goyo Ikong, Woka Town Goyo Ikong, and Chukitong Goyo Ikong shall be inducted into the Goyo village council. The aforesaid resolution is perfectly in keeping with the Lotan Naka customary law. It is the established Lotan Naka customary law that a native of the village may take up residence at a place away from the village for reasons of livelihood. But he retains full citizenship of the village and continues to enjoy all the rights and privileges as any other citizen residing at the village. The only exception is where the person, after disposing his property in the village, migrates to another place to establish a new village, or migrates to another existing village and becomes a member of that village by adopting a father in that village. In such a case, the person voluntarily relinquishes citizenship of the village of his origin and becomes a citizen of the new village or the village of his adoption, as the case may be. As regards the respondent, he is a permanent citizen of the Goyo village. Neither the respondent nor any of his ancestors have disposed of their ancestral property in the village and migrated to another village at any point of time. In the instant case, Chukitong town, where the respondent resides, is a town established on Goyo village land. A large portion of the Chukitong town belongs to the respondent's clan. The Chukitong town and Goyo village are contiguous. It's a continuous development. Contiguous, where the Goyo village ends, the Chukitong town starts. Considering that the respondent and his family have ancestral land falling within the town, the respondent has set up residence on the ancestral land falling within the town jurisdiction, but continues to participate in all important activities of the village as though he resides in the village. This is the position. In consonance with the aforesaid village resolution dated 19/10/2017, the Chuchuroi Kikon clan of Goyo village, of which the petitioner and the respondent herein are members, adopted a resolution dated 16/6/2009 to the effect, inter alia, that the clan member selected by the clan to be VDP member or VCM member must act in accordance with the clan's decisions, and if he fails to do so and act according to his own will, he will be made to resign and another member will be selected as his replacement. In this regard, mention may be made that other clans of the village have similar resolutions in place. Here it is pertinent to state that not even a whisper has been made in the petition about the existence of the village resolution dated 19/10/2017 and the Chuchuru Kikon clan resolution dated 16/6/2009. The petitioner is therefore guilty of suppression of material facts. These are material facts, Your Worship. How the village goes in election, selection of members and retention, how the village goes about. They have resolutions in place. All the clans also have their separate resolutions, which are similar in nature. This is how it goes. Now, paragraph 6, Your Worship. That with regard to the statements made in paragraph
No,
6,
before that,
yes.
what resolution dated
Your
16,
Worship, I'll take Your Worship to the annexures.
16/6/2009?
Yes. Annexures. I'll take Your Worship to the annexures. Annexure 1. This is Annexure 1. This is the page 21. Annexure 1. This is in their own dialect, so it has been translated in which is in page 24. Translated copy, page 24.
Yes.
So here, how village council Here, in paragraph 2, conduct of elections. This is with regard to general elections in the state.
No, that come
This
to
is, yes, no,
relevant.
6, I am sorry, page 25, paragraph 6, Your Honor, page 25. A, for the betterment of the village, it has been resolved by the House to introduce village constitution. B, for the betterment of the village, Koyo village people residing outside the village will also be included while forming. It has been resolved by the House to induct 2 representatives each from Koyo village Ekong, Woka Koyo Ekong, Woka town Koyo Ekong, Chukidong Koyo Ekong in the Koyo village council. So this is the resolution. And all the others are relating to village administration, important aspects. Now, page 28, Your Lordship, Annexure 2. This is the clan resolution. Annexure 2, page 28, dated 16/6/09. Chichuroi clan meeting and resolution. Number 1, the clan made the resolution that whether VDP member or VCM member, what the clan decide and agreed upon to support will be allowed to hold the member after the clan resolution. If the individual does his own will, he will be made to resign and select another member to be the member. 2, the clan resolved that in the future, if the selected clan member does his own will, the clan will not accept and he will not be allowed to hold the member. Number 3, the clan resolved that whether VCM or VDP member, if the concerned does not obey, follow the clan resolution and not for chairman or VDP secretary, he will be made to resign. So this is the resolution which was adopted by the entire clan, which includes the petitioner as well as the present respondent. He cannot deny that during his selection, I was also part of the members who selected him, Your Lordship, because it is a clan affair.
So you are submitting that there is a resolution of the clan in 2009.
Yes.
That if somebody goes against the will of the clan,
yes,
he may be made to resign.
Yes, and then they will no longer accept him as representing the clan. That is the resolution which he is also part of. I am also part of. We go by this. These are normally customary laws which has been just written down to remind everyone. Otherwise, this is the normal in every village. This is what goes on. You select someone to represent the village. They have to work for the interest of the clan. Unless he does that, he cannot be.
He'll be made to resign.
That is, yes.
He'll be made to resign.
As per the way they have written it, they are saying that yes, in the first.
Suppose he does not resign.
So now all they have to do is they replace him. That is how we do it. They replace him customarily. The custom is they will tell him you resign. Since it is a moral.
But this resolution, if we read this resolution, it says that
yes,
the VCM member would be made to resign, and thereafter a new member would be selected.
Yes, that is what they are. It is written. Yes.
But
the second one, he will not be allowed to hold the member. In the second one, see, the second paragraph. These are.
But for that, there is a statute also governing the affairs of village council.
Yes.
So that statute provide for contingencies when you may be a member may be removed,
yes,
or when he can be disqualified.
Yes.
Many grounds are there.
Yes, Your Lordship. It is there. It is there. Yes. It's undisputed. It is undisputed. it is there. But the peculiar thing in Nagaland is, this is what is going on. And normally the state has to also go by the decision of the village, because once the village decide that his member, we are no longer, we don't have any confidence in him, he is out. Then the government cannot force the villagers to.
No, then the government can take recourse to Section
Yes.
9.
Section 20, Section 20. Your Lordship, the law has been caged in such a way, normally every act should have rules. The procedures should follow, but unfortunately in our state, there is no law, no rule accompanying the act. Everywhere throughout the country, wherever an act is there, normally procedural, the rules also follows. But this is the position, Your Lordship.
That is true.
This is what is going on.
We don't have a rule.
Yes.
So for interpretation of even for the act,
Yes.
now government is relying on Section 20.
Yes.
So what kind of dispute? That is not there in the rule. But as far as the act is concerned, as of now, Lordship,
It is a very vast kind of, even the section itself is very vast. If there is a dispute, that means
Dispute
now
may be
he
of
has
any
been
kind.
selected by the same clan, again, subsequently in his replacement, I have been selected and sent. Now
That is a dispute.
it can come under the
Purview of dispute.
purview of dispute, Your Lordship.
Okay.
This is the position we have to, and even the court has difficulties when it comes to, because the law should be very definite and specific, but in Nagaland, you
No, but you have to help the court.
All these things every now and then.
No, you have to help the court.
Yes.
How the
Yes.
statutory
So-
provision should be interpreted.
Yes.
Yes.
So what I am submitting is
act
that
is clear. Act is
customarily, this is what goes on. The custom is you select one of your own clan members to represent you in the village council. If he goes against the wishes of the village, the clan members come together and say, no, we no longer we are replacing you. This is what is going on. Because that was the custom, normal custom everywhere. Even among the other tribes, this is going on. I've come from the Ao tribe. In our case, we have this 30 years, system of selecting the rulers of the village, one generation. What happens is that for us, we don't have elections. Village council elections like the other tribes. Even the village council act is clear. For the Aos,
It is hereditary, 30
yes,
years.
it is not, those who are already elected for 30 years, they will be the village council members. Only every 5 years, we have to change the village council chairman. We have elections for the village council chairman as per the act. But so far as membership is concerned, we don't have elections. This is why we don't get this kind of disputes. But internally, in the village, what happens is, if my own clan who is representing us, he goes against us, what we do is, you are now out. We are replacing you with this person. This is the traditional thing that has been going on. So he automatically, the one whom we replace, he automatically becomes a member of the village council representing our clan. This is what is going on. So even in their case, internally these arrangements are there.
As far as all is concerned, understood.
Yes.
But as far as my clan is concerned, I should resign. That's the resolution. I have not resigned.
Your Lordship, but I am only submitting as per what is the prevailing position.
Okay.
Yes, as per the language, Your Lordship, and even the English, the language in which it is written, they have difficulty in framing the whole thing. So it is also not.
Is it not proper translation?
This is the original, Your Lordship. If I,
Original is in which language?
this is what was. Yes, this is the original, Your Lordship. This is the original.
Which my learned friend is relying is the original.
Yes.
Page 28.
Yes, this is the original, Your
This is the
Lordship.
original.
Yes.
In English.
The language is clear in,
Yes, but the way,
It's not a
the way
translated-
they are
it's not a
contriving
translated.
it, the way they are contriving, the way they have written it, Your Lordship. Some difficulty you can see in how they have framed it, we can be ascertained from the way it is written. The first one says you will be made to resign. The second one says that you will not be allowed to hold a member. Lordship. So even without resigning, he will not be allowed to hold, to be the member. The village folk, Your Worship. So these are the difficulties involved, but that is the position. Now, so as per the resolution, what happened was, on the based on the village guideline as well as the family resolution, we selected the
respondent number
the
5.
petitioner. The petitioner was first selected.
Yes.
We came together when the notification came from the state government and direction was given to the village. Every clan was given information to select and then send a representative. So accordingly, the petitioner's name was selected and it was forwarded. Now, Your Lordship, the problem was when we selected him, the understanding was that he will vote for a particular candidate as a VCM. That was the understanding. Our clan had decided that one particular person, when you are finalize your appointment and all, you have to, our clan will vote only for this person to be our village council chairman.
Village
Well,
council
it was
chairman.
agreed.
Okay.
What happened was, after his name was sent, he started working for the other one whom the clan decided not to support. So the clan was not happy. They called a meeting, convened a meeting to discipline him. They called a meeting on a certain date because all these meetings are conducted orally. So on a certain date, conducted, when meetings are called, we don't send letters to the family members to attend. We normally convene a meeting at such and such time, all of us must come together. So a date was fixed, meeting was conducted. What happened was, he boycotted. So ultimately now, the clan had no other option but to replace him. The clan decided, no, he cannot do this. He is going against our wishes. When we call him for a meeting, he is not even coming to the meeting. So now we will change his name. We will replace him. So what happened? During that meeting, I was elected by the clan itself, in his absence, obviously, because he boycotted the meeting. So my name was sent. Again, that we are replacing him because he is going against the clan. So we are sending this person's name to replace him. And this is how the controversy arose. Now he knows all these things, but what happens is he has not even made a whisper in his petition. He knows all these developments, but what he is saying is, I don't know what went on. I just heard that some vested interested persons whom I don't know.
Because he abstained from meeting.
Yes, but he knows that it's a small clan, Membership is not very big. Everyone in the clan, he is also living in the village. I also live in the village, on the periphery of the village, because the town starts in that area. So he knows what is going on in the clan itself, within the clan itself. He ought to have at least come before this honorable court that because of these reasons, they decided to replace me. But These are important facts. Why the clan had to take this drastic step? He knows that very well. He has knowledge of it, but he has suppressed those facts. He is ignore.
You have mentioned these things in your affidavit.
Yes, Your Lordship.
Okay, okay.
In paragraph 6 onwards now. From paragraph 6, Your Lordship. That with regard to the state, if I may read, Your Lordship.
Yes.
If I may read, Your Lordship. Paragraph 6. That with regard to the statements made in paragraphs 6, 7, 8, 9, and 10 of the petition, it is not denied that initially the petitioner was selected by the Chuchuroi Kipon clan of Goyo village, and his selection was forwarded for government approval by office bearers of the clan. However, subsequent to his selection and forwarding of his name by the clan, he refused to abide by the decision of the clan by making commitment to support a candidate for election to village council chairman whom the clan had decided not to support. His action being a clear violation of the resolution number 1 of the Chuchuroi Kikon clan resolution dated 16/6/2009. The clan was compelled to convene a meeting on 2/6/2021 to deliberate on the matter. Despite being informed to attend the meeting, the petitioner deliberately absented from the meeting, and therefore the clan decided to replace him by selecting a new candidate, and accordingly the respondent was selected by the clan to replace him. Thereafter, the clan office bearers by letter dated 10/7/2021 informed the head GB Goyo village that the clan had selected the respondent to replace the petitioner because the petitioner had violated the clan resolution number 1 dated 16/6/2009 and requested acceptance of the clan decision in the larger interest of the clan. Along with the letter dated 10/7/2021, the clan also submitted selection dated 2/6/2021, a declaration dated 10/7/2021, and a certificate dated 10/7/2021. In the declaration dated 10/7/2021, the clan declared that the petitioner was elected by the family members to represent the clan as VCM. But since he refused to abide by the clan decision to support Konpensao Kikon as the village council chairman, and instead declared his support for another candidate, Sri Renpamo Izong, and thereby violated the clan resolution dated 16/6/2009, the clan decided to elect the respondent as VCM. In the certificate dated 10/7/2021, the clan further certified that since the petitioner did not follow the clan resolution dated 16/6/2009, the clan decided not to allow him to hold membership of the village council, and that the respondent has been elected to be the VCM for the tenure 2021 to 2025. The head GB Goyo by letter dated near forwarded the matter to the EAC Chukidong, and the EAC Chukidong by letter dated 15/7/2021 forwarded the matter to the Deputy Commissioner Woka for further decision and necessary action. The Deputy Commissioner Woka by letter dated 16/7/2021 also forwarded the matter to the Commissioner Nagaland requesting necessary action from his end. The Office of the Commissioner Nagaland also by letter white number so-and-so dated 22/7/2021 forwarded the matter to the Principal Secretary Home, Nagaland for further necessary action. Thereafter, the government, having considered the matter by letter white dated 2/8/2021, conveyed approval for replacement of the petitioner by the respondent. Consequently, the Office of the Commissioner Nagaland by letter dated 10/8/2021 conveyed to the Deputy Commissioner Woka the approval of the government to appoint the respondent as VCM in place of the petitioner. Here, it is pertinent to state that the petitioner was perfectly in knowledge of the facts stated here and above, he being a member of the Chuchuroi Kikon clan himself, and yet he has deliberately suppressed the same while approaching this honorable court by making false statement that sometime in the later part of July 2021, he was informed from reliable sources that there has been some move by some vested interested persons to replace him by the respondent. And adding to the falsity of such statement, also has made another audacious false statement that the respondent hails from Chukidong village when Chukidong is not a village but a town established on Goyo village land. It is obvious that had he revealed the aforementioned facts on record in the writ petition, this honorable court might not have passed an interim order dated 2/11/2021. It is settled below that the petitioner approaching the writ court must come with clean hands, put forward all the facts before the court without concealing or suppressing anything, and seek an appropriate relief. But the petitioner has failed in his duty, hence the petition is liable to be dismissed for suppression of relevant and material facts by the petitioner. So this is the position, Your Lordship. Now, the annexures. I'll take Your Lordship to the annexures. Yes, starts annexure 3 onwards, Your Lordship. Annexure 3 onwards. These are official records. This is why page. Yes, yes, yes.
Annexure 3, page 29.
Yes, page 29, Your Lordship. So during that meeting, the petitioner was selected by the clan. The clan during the meeting, yes, oh yes, Your Lordship. Respondent, the present respondent, I was selected during this meeting
By
the clan itself. The ones
by
who,
29 households.
yes, because these are even the petitioner's name.
He was selected by 44 households.
Your Lordship, now 29 of them, his group did fail to turn up, Your Lordship. This is the position. Now we are the majority, Your Lordship. His group, yes, his group failed to turn up.
Okay.
So ultimately this decision was taken. The clan was compelled. It was not to replace him. The meeting was conducted, but to reprimand him and to tell him that he has to go by the clan resolution. But what happened? Deliberately, he avoided the meeting. So now even this fact he has failed to highlight in his petition. He has suppressed this fact, as though he is clean everywhere. Translated copy is at page 31, Your Lordship. Now, page 32. This is the letter by the ESA to the Deputy Commissioner with regard to our page 32, right? Oh, I'm sorry. This is missing here. Oh, no, 34. Yes, and then the pages are, Your Lordship, I'm sorry, the pages are jumbled up in one petition. Page 32 is the clan's letter. This is a clan chairman, Your Lordship. Clan chairman and secretary. Their letter to the head chief. So the clan office bearers, they wrote to the head GP that we are now replacing them. Now based on that, and then the declaration is at page 33, Your Lordship. The declaration of the clan. So this is in their own dialect. Page 34 is a translated. They are making a declaration that henceforth the petitioner has been replaced by the present respondent. Now, Your Lordship, This is the certificate which was issued by the page 35 is the certificate annexure 6 issued by the clan certifying my selection. Then next page, page 36. This is the 8 GB Goyo village forwarding letter of our decisions. Then page 38. No, 37. Page 37 is the EAC, letter to the Deputy Commissioner, forwarding my case to replace the petitioner. Now, is it all right if I don't read it, Your Lordship?
No, yes. No, not required.
Yes. Then page 38 is a same one. Oh, the letter which was type copy, Your Lordship. Then page 39 is the deputy, another letter by the EAC. Type copy is at page 40. No type copy. Oh. But I think this is the same one as this one, huh? It's all jumbled up though. This is the one. This is type copy, yes. Oh, the type copy is at page 37, Your Lordship. I'm sorry. Then page 40. This is the letter of the Deputy Commissioner. Page 40. Deputy Commissioner to the Commissioner Nagaland on the same issue. Then page 41 and 42. 42 is a type copy, which this is a letter of the Commissioner Nagaland to the Principal Secretary Home. And then page 43, which is the imbued order in the earlier in the writ petition, Your Lordship. Be replacing the petitioner.
Okay.
And so page 45 is the order which was issued on the basis of the government letter to the Commissioner Nagaland. So this is the position. Now, Your Lordship, I would like to take Your Lordship to another aspect of the writ petition, where, which is also a kind of suppression of material fact, Your Lordship. Here, the present petitioner has annexed an order of this Honorable Court, which is at page 46 in the writ petition, Your Lordship. In order to support his case, he has annexed this. Here in this is an exactly similar case. I'll take Your Lordship to the final order judgment which was passed in this case. This is exactly the same case with that earlier case. I'll take Your Lordship subsequently to it. But in this case, the petitioner had raised the issue that since this private respondent resides in Chukitong, the same town where I am residing, he ought not to have been selected. He is not eligible. So what happened? This Honorable Court decided to direct the authorities by this letter to verify whether the respondent, private respondent, is a legitimate, is eligible to be elected as a
in earlier case.
In that earlier case.
Okay.
And in that case, there was a certificate which is annexed at page 48, based on the order of this court. Page 48. This was a certificate issued by some GBs of Koyo village. Some GBs of Koyo village If I may read, Your Lordship, because this is a little, it's not very clear, also I will just read it. Certificate, reference to the Lota Naga customary law, practices and usages, page number 79. Yan Sanman, run away. Number 1, narrates that Kyong Lota Naga hereditary and inhabitation in a particular village refers to any person who left his ancestral village and inhabits to another new place. Then that particular village authority will not extend or give any birth post in the village administration. Reference to a book titled Nino Unti Yanla. What are you searching? Written by D. Gikon, ex-minister government of Nagaland, page number 7. Also refers that selection of village chief, chairman, tongti and associates, council members called Chochang and Pange in Lota were chosen by the inhabitants, people of the village, general public, but not through hereditary. Now referring to Sri Hatongo Kikon, presently including in the list of VCM of Koyo village, is highly objectionable by the villagers of Koyo because they voluntarily left Koyo village and settled as Chukitong village and passed for almost 3 generations. Now their family members are living happily at their permanent present and proper address at Chukitong village, enjoying all government schemes and benefits. Therefore, now they have no right to claim any post births within the village administration of Koyo, where the family roots of Hatungu Kikon has no any attachment to Koyo village. This was the one that was sent. Now, in my affidavit, Your Lordship, what followed after this? I will take Your Lordship's to. Huh? The court's order. Court's order. This is the final judgment order, no? Okay, no. Page 46. Now, subsequent to this, Your Lordship, page 46, Your Lordship, this is the order which was passed.
Page 46 of?
Page 46 of my affidavit. Affidavit. Subsequent to this order was passed in that particular case. If I may read from paragraph 2 onwards, page 47, if Your Lordship, this is dated 11/11/2021. The earlier order which is in the writ petition is 8 of September 2021. No, 24 of August 2021. In the earlier one. Now, subsequent to the submission of this, dated 11/11/2021, what happened? This court had earlier, by an order dated 24/8/2021, directed the head GP and GPs of Koyo village to file an affidavit or a certification as to whether a person having roots in a particular village can be considered as member of the village and therefore eligible to be elected as village council member. Today, when the matter was put up for consideration of the matter, it has been observed that 2 different certifications have been submitted before this court by the village GPs of Koyo village. The petitioner submitted one certificate which is in the writ petition. The respondent also submitted another issued by the head GP and others, and these were conflicting, Your Lordship. First is an affidavit containing the signatures of 5 GPs, namely Kansurao, Nchompimo, Ramomo, Yanpamo, and Wokango, certifying that for a person who leaves his ancestral village and inhabits a new place, the said individual would not have the privilege of getting a birth post in that particular village administration. The other certification has been issued by the head GP, Koyo village, Sri Ikong Huli, GPs, Sri Fovisho Kikon, Sri Rendimo Patton, and Chairman, Chukitong Range GPs Union. Sri Ponchiro Kikon certifying that as per prevailing customary practice of Lota tribe, a person who has roots in a village and who resides outside its jurisdiction has right to be elected as village council member to represent his clan. This writ petition, besides other legal issues, particularly revolves around the issue as to whether the respondent, Mr. L. Yanpimo Kikon, can be considered as a bona fide citizen of Koyo village under the facts and circumstances of his standing at the present moment, so that he may be eligible to be elected as a member of the village council in Koyo village. Unless this issue is answered, we are helpless to dispose of the writ petition in terms of the Nagaland Village Councils Act. Therefore, having received diverse certifications from the village authority, it is observed that it is necessary to again give a fresh direction whereby the entire GP of Koyo village along with the head GP and also the Asarwe Kikon clan of Koyo village may participate and to take a decision as to whether Mr. Yanpimo Kikon may be regarded as a bona fide member of Koyo village and eligible for election to be village council member. In view of the difficulties faced by this court, it will be appropriate if the Deputy Commissioner Woka gives a direction to the EAC of the concerned area, who is also respondent number 4 in the present writ petition, to convene a joint meeting with the chiefs of Koyo village along with the Tobashis of Asaroi Kikon clan to ascertain as to whether the respondent Mr. Yanpimo Kikon is a bona fide member of Koyo village eligible to be elected as village council member. The report should be placed before this court through the government advocate on or before the next date of hearing, that is 2/12/2021. Now, subsequent to this, information was sent by the EAC circular, page 50, Your Lordship, to ascertain whether the respondent therein is a bona fide member of Koyo village. Now, verification report, Your Lordship. This is page 51, 29 November 2021. Page 51, if I may read, Your Lordship.
Yes.
In pursuance to the Honorable High Court registration case number so and so and as directed by authority, the undersigned along with the GBs and members of Asarwe Kikon clan held a joint meeting on 29 November 2021 in DB's court, Chukidong at 10 a.m. The meeting started with a brief explanation of the case by the undersigned, and all parties present agreed on the below mentioned points. That Asarwe Kikon clan consists of the following family lineage, starting from late Asa to Mr. Yanpimo Kikon. These are the up to 8. 2. That late Senimo Kikon, who is also the grandfather of Mr. Yanpimo Kikon, shifted to Chukidong Town in 1957, and since then all his descendants, including that Mr. Yanpimo Kikon, continues to stay in Chukidong Town till date. That Mr. Yanpimo Kikon is a resident of Chukidong Town with his house tax, ration card, and electoral roll, all having Chukidong Town as his permanent address, but a member of Koyo village, as stated in his scheduled tribe and indigenous inhabitant certificate. 4. That as per resolution number 6B of Koyo village, general resolution of 2017, dated 19 October, reservation for VCM was given to all resident union outside Koyo, namely Hoka Koyo Union, Kohima Koyo Union, Dimapur Koyo Union, and Chukidong Koyo Union enclosed. Therefore, in the light of the above findings, it can be stated that Mr. Yanpimo Kikon is a member of Koyo village who is a resident of Chukidong Town. So in this case, the elders arrived at the conclusion that though he resides in Chukidong Town, he is a member of the Koyo village. Same is my case here, Your Lordship. Now, after that, all these reports came, judgment, Your Lordship. In this case, what happened? This is an exactly same case. In this case also, the clan selected the petitioner initially. Now, again, in this case, the petitioner reneged against the clan decision. The clan convened meeting. He boycotted. The meeting was conducted, then what happened? In the meeting, finally, the clan members decided that we'll replace this petitioner. So they sent the respondent's name to replace the petitioner in this case. Now the government also replaced him. And this is the same election. This is the same election. The only thing is that this present petition is being taken up only now, but this was taken up in 2021. This is
The earlier petition was in relation to
the same village.
same village but
Same
different.
village but a different clan. The clan, yes, both are Kikon clans, but then they have their own, again, sub-clans. So these two clans, they are, the present case, the clan name is same, Kikon clan. But they belong to one branch of the Kikon clan. That is called, they are called the Asaroi Kikon clan.
Different village.
Same village.
Same village.
Same village, Koyo village on that.
Actually, it's not a sub-clan, it's family.
It's a family lineage, yes.
They all kick on, but they take a grandfather's name.
Yes.
So I belong to this.
But under section 4, they are members of the same village. Section 4, that villagers to select VCM.
Yes.
They are in the same group.
Yes. Lordship, the second aspect of the matter which Madam Friend is saying, I'll clarify to that, Lordship.
Yes.
I'll clarify. Because this should not be mixed up with the other.
These two groups, in the earlier case, in this particular, in this case which I'm referring to, in this case, they have their own, they have to select their own member as VCM. In the present petition, this particular group also has their assigned member to be selected. So they do it separately. So selection was done separately in this case, but the election pertains to the same election. This judgment of this particular case which I am referring to now is the same, the case dispute that arose in the same election.
What happened in?
In this case, the Honorable Court directed the village to take steps to conduct a fresh election. Worship. If I may take your worship to the conclusion, page 66. Page 66. The second paragraph onwards, Your Worship. Two groups have sent several candidates supported by different voters. This is not in keeping with the provisions of the Section 4 of the Nagaland Village Council Act of 1978. Under the circumstances, this court is unable to recognize the candidature of either the petitioner or the respondent number 5. In consequence, all correspondences or approvals made with respect to appointment of VCM of Kohima Village are hereby quashed and set aside. The report dated 29/11/2021 of the respondent number 4, that is the EAC, with respect to the status of respondent number 5 shall however not be disturbed, since it bears the signature of the petitioner himself. The respondent number 3 is directed to take steps to conduct a fresh selection for the VCM of the Asaroi clan of Kohima Village without any further delay and take steps for necessary approval of the government. So,
the earlier writ pertains to Asaroi clan.
yes, Asaroi. Now it is Chuchuroi.
Chuchuroi
This is Chuchuroi.
And in earlier petition, there were two groups sending two names.
That is what
In the present petition, it is
no,
a
Your
different.
Lordship, the facts are, if I may take Your Lordship to the fact, what happened was, so many complicated, he also raised so many disputes. And my ground also was that he has suppressed material facts. The court has also discussed that aspect also here, in this case. But I am coming only to the conclusion. Now the court somehow, though it is in the petition, in the judgment itself, he has recorded all the statements that the same clan selected another party for replacing him. All those are there, but ultimately he came to this conclusion, this honorable court. But the effect was that you conduct election afresh, whoever the clan select, let him be the member. So accordingly, fresh elections were conducted in this case, subsequent to the judgment, and selection was done. In that case, the fact is that the clan reaffirmed the election of the private respondent. So the private respondent who subsequently replaced the petitioner in this case, he was elected by the clan. In that case also, yes. That is the position. But since it is not on record, my submission about this election is off the record because this case does not deal with what happened in that case. The only thing is that we are dealing only with a similar, and the sets of facts are same here. If I may take your lordship to the judgment is on the facts.
Okay.
It may take time to read, but if your lordship may permit me, I'll read the facts which
No, I'll go through it.
This case has got, the facts is different, as your lordship has rightly pointed out. In the previous case, there were two groups. saying that this is my candidate, this is my candidate. Two groups.
Indians,
My case here is
same people recommended him. Later
And
on, same
yes,
people
yes,
replaced.
Yes.
that I'll
In
distinguish.
that case also the same thing happened, Your Lordship. But somehow, because the facts I have laid down in even my submissions are clearly there here, the court. But when conclusion times, this judgment was passed. But the effect is that you conduct a fresh election. If a fresh election is conducted, Your Lordship, fairness for everyone, all concerned, I would have no objection if a fresh election is conducted. I will have no objection as in the earlier case. Because that is the best middle ground that this honorable court can take.
No, but whether this village council act contemplates under what circumstances fresh election?
Section 20, my submission, my honorable, my humble submission before this honorable court is that since this pertains to election, this pertains to the election, as to who should be the legitimately elected persons from the clan. Section 20 will cover it, Your Lordship. Section 20 says if there is a dispute, then it is for the government to decide. The government's decision is final. But obviously, of course, this honorable court's power of judicial review cannot be excluded in such cases. But Section 20 says that the decision of the state government is final when there is a dispute with regard to election or selection of a candidate. So these can be applied in the instant case. Now there is a dispute. It came before the government. Now our dispute is that he was elected, now we are cancelling it. In terms of the village council act as well as the customary laws. The village council act clearly says that election should be as per the customary practice. Customary practice is the most important aspect. So now according to customary practice, initially he was elected, but then according to customary practice again the clan decided to replace it. So now a dispute has arisen as to who between these two should be the one who should sit. Now if that is the case now, I have no objection, to be fair. Set aside both our selection and then direct the authorities, the state authorities to conduct a fresh election with respect to the particular clan which is involved in accordance with the customary law.
Okay.
That is my humble submission before this honorable. Oh, Your Lordship, with regard to the suppression of material facts, Your Lordship already knows the position, but I'll make some submissions. I'll just quote the paragraphs and these are one is 2007-8 SCC 449. Paragraph 33 to 36, Your Lordship. 33 to 36 will do, Your Lordship. And then the second one is 2008-12 SCC 481, paragraph 36 to 38.
Regarding suppression of fact.
Suppression of material facts by the petitioner. Yes. The position is very clear. Even if the petitioner may have a good case in the first place, but if he has suppressed facts which are material to the case and approaches honorable court and obtains some kind of order.
And your submission is he knows everything.
He knows everything.
But on what basis you are saying he knows?
It is a
small clan. Therefore you are saying.
Small clan in the village, small village. To be told is one of the smallest villages in the state.
That is your basis of.
And the village, all the members are aware of what is going on in their own clan. Here, at least, he should have said that they selected me, but now they have tried to change my, they have tried to replace me. He knows that it is the clan which replaced him. He knows that. But he has come before this court saying that some vested interested persons whom we don't know. That is suppression of material fact.
No.
Your Lordship. It's a pertinent issue, Your Lordship. You cannot lie before this honorable court. It is a lie, blatant lie. At least he should have made a statement that it was the clan which decided to replace him.
Sure.
These are facts which are pertinent to the case. Ultimately, it is for the court to apply its mind and apply its discretion and decide. But whoever comes before this honorable court must come with clean hands. As simple as that. Whether there are good points in your favor or bad points in your favor, you have to bring everything before this honorable court. Show it, the ugly, the bad, and the good. But in this case, he has not done that. He has deliberately suppressed his fact. He knows what is going on. He even knows about what the move. This is why he had written to the government that do not replace me. Since I am getting some information that some vested interested persons are doing it, do not replace me. Your Lordship, what is this? It is a blatant lie before this honorable court. They must not be allowed to do that. So, Your Lordship, I'll just read one paragraph of the 2007 because all the relevant law is same in both cases.
Para?
Para 33. This is 2007, the first one. 2007 SCC 449, and the relevant page is 461.
Yes.
Para 33, Your Lordship, if I may read. It is thus clear that though the appellant company had approached the High Court under Article 226 of the Constitution, it had not candidly stated all the facts to the court. The High Court, in exercising discretionary and extraordinary jurisdiction under Article 226 of the Constitution, over and above a court of law, is also a court of equity. It is therefore of utmost necessity that when a party approaches a High Court, he must place all the facts before the court without any reservation. If there is suppression of material facts on the part of the appellant or twisted facts have been placed before the court, the court may refuse to entertain the petition and dismiss it without entering into merits of the matter. So, the principles that are decided some earlier judgment is given, but that is the crux of the case here. Twisting the facts, Your Lordship, suppressing material facts.
Okay.
That is so. This is a case where the petitioner has suppressed material facts and twisted the actual facts, presenting it in a way which is not a real. So, on this ground, also the petition is liable to be dismissed, and the earlier judgment also applies in this case. That is my humble submission before this honorable. I raise.
Thank you, Lordship. I'll just take a short time, Lordship. Now, all the while the private respondent is saying that I knew all these facts. That is a false statement, Lordship. Things were done behind my back. Lordship, I'll just refer to one document. My learned friend has stated that the private respondent was there when I was selected. That is a false statement, Lordship.
When you were selected?
He said that he was there. He elected me. Lordship, I will not be kindly allowed to take to Annexure D of the repetition. 26, page 26. I don't see the private respondent name here. This is the local dialect, Lordship. The translated copy is at page 29. Page 29. There were 44 households who voted for me, Lordship. 44%. The name of the private respondent is not here. I don't see his name. Lordship, I kindly see the language, Lordship. We, the house taxpayer of Chuchuri Kikon clan, have unanimously selected Sri Info Kikon as VCM of Koyo village for tenure 2021 to 26. The private respondent name is not here. One is Info, second is Yambemo, Ezambemo,
okay.
Zamkomo. No, his name is not there. So his statement that he selected me is false. He was not there when I was selected. Now, Lordship, I kindly see his selection list again. This, Lordship, this document is of head at serial number 40. Actually, it's Lamjabo. this is the same person. And the Chobemo, that is serial number 24, and in my list, serial number 11. Lordship has found?
Yes.
Now, Lordship, let me see their document. This is a type copy. These two persons have not signed. Rest names does not tally. None of the name tallies. That's the reason why I did not know about this document. These were all fabricated documents. Only two name tallies, Lordship. In my list at serial number 11 and 40, and in the list at serial number 22 and 24. And in their list, these two persons have not signed. Because they voted for me, they didn't sign here. These are all fabricated documents, Lordship. He is saying that we are living in the same village, it's a small community, but things can be done hidingly, Lordship. They said that they convened a meeting on 2nd of June, if I'm not mistaken. Yes, 2nd of June. There was no such meeting. I was not called. So the question of suppression of material facts does not arise, Lordship. I have not suppressed any material facts. I knew of the step taken by the private respondent in connivance with some of the members.
Out of these 29,
6 has not signed.
6 has not
signed. And the two men that appeared in their list, which appears in my list also, have not signed. This apparently is the list prepared by the clan. And this is my list is prepared by the HGB as per the house tax paid by us. So which document will hold the ground now, Lordship? HGB is a statutory authority, a person appointed by the government. He has given the names of those people who are paying tax because they pay tax to the government, house tax, a nominal fee. I was selected by the house taxpayer, which has been duly signed and authenticated by the HGB. Their document is prepared by the so-called chairman and secretary of the club, where even their names are not there in the house taxpayer. This is how the private respondent has managed to manipulate the documents. And now they are taking the ground saying that I knew of all this aspect of the matter and I have suppressed it. Where is the question of suppression? When I don't know, when people who have signed is not in the list of the HGB. Your Lordship, the case that my learned friend was referring to, the old case, there were two groups. This is my candidate. One group says this is my candidate. So, that one person who was selected, he was replaced. He went to court. So there was dispute between two groups. My case is, there's no dispute. Though his name does not appear in the list when I was selected, but he fairly admitted I selected him. Now I want to replace him. Going by the act, Lordship has pointed out, even the resolution of the club, resolution 1.
Made to resign.
Made to resign. I did not resign, Lordship, because I was enjoying the majority of the clan members' confidence. If they're saying, state respondent has already admitted, and as a matter of fact, Lordship, once a person is selected, elected, and approved to hold the post, to remove him, Section 9 is there. To disqualify him, Section 16 is there. Now the state respondent is very conveniently coming up saying that taking the power invested under in section 4 and 20. We have replaced it. Thus, section 20 says about replacement. Lordship, mechanism language. If there is any dispute, the decision of the government will be final. Either disqualify me or remove me, but not replace. Yes, my letter friend has pondered so much upon the rules. I also admit that fact, there is no rule, Lordship. So the act can be interpreted in your own convenience, Lordship. But as far as this present case is concerned, if there is a provision for replacement, Lordship, I will not argue this matter. There are only two ways to remove. Remove or disqualify me. So if government has to act as per section 20 of the act, government either has to remove me or disqualify me. My learned friend was conveniently relying on section 9 clause 1b. Who refuses to act or become incapable of acting. State respondent has relied on section 9 clause 1 subclause b. I was removed because of this. That is a submission, Lordship. Though no specific, like my friend was saying, act is there. If they say I have been removed in view of section 9(1)b, Lordship, who refuses to act or become incapable of acting, if I admit this was a ground, Lordship, I should disobey what the government directs me, not the clan, Lordship. Clan aspect is one of the aspects of the matter. But this is an act. This is statutory act, Lordship. No. Yes, Lordship. Now, my learned friend has very conveniently gone to the extent of saying that I went against the decision to vote for a particular person, which was against the wish. It's just a statement. Where is the record to show that I voted for this person, I voted for that person? A member, MLA, is elected. He sits in the assembly for a chief minister post. I vote. I don't listen to my electorates. I represent them. I'm sitting there. Even assuming that, okay, clan can impose that. Why did they send me first? Lordship? If they say so. This is purely vested interested. That's why I've used the very word, Lordship. Vested interested person. Name does not tell me, Lordship, whether the genuineness of the documents relayed by my learned friend, the private respondent, can be taken as a gospel truth. Intimation was between the HGB and those persons. Everybody knows, Lordship, like the private respondent saying, I also know what was going on with them. But I did not know these documents. I knew they have moved to replace me. That's why I wrote the letter to the DC. This is not a clan decision. Some vested person are there involved to replace me. So I've written to the DC. This is my justification. But DC, instead of sending my justification clarification to the government, kept aside my clarification, but very conveniently sent the private respondent documents to the government. And when my replacement order came, did they invoke any provision of the Act, Lordship? They are saying, my learned friend is saying section 20. If I may be allowed, Lordship, any order that is passed as per an act in exercise of the power conferred under section so and so, we have been replaced. That has not been done, Lordship.
Still.
So as far as the submission of the learned private respondent, that I have suppressed material fact, Lordship. I have shown the record. There was no suppression of material facts, Lordship. I knew the move was on, but these documents were never in my possession. They have never copied to. They should have acknowledged, we are taking action against you. You are not listening to the client. Was it endorsed to me? Was a copy endorsed to me, Lordship? None of the document. A copy has been endorsed to me. How will I have access to these documents, Lordship? No copy was given to me, Lordship. All this communication, the private respondent document, Lordship, where they are alleging that I am suppressing facts. None of the copy was given to me. No intimation was given to me. Rightly or wrongly, I am the selected VCM of the clan, Lordship. If they want to remove me, they should give me a copy. No, it was not given, Lordship.
Okay.
And apparently the state respondent, my learned friend, he was speaking for a clan. He should have taken a neutral stand, the state respondent, by sending both my clarification and the private respondent documents. It was one-sided. So they were all hand in gloves to replace me. They were all out to replace me by any means. And now coming with an affidavit saying that we have invoked section 20, we have invoked section 9, 1B. They're always silent. They cannot give a submission and rectify their mistakes. That's my humble submission, Lordship.
Your Lordship, one small aspect. These submissions which the present my learned friend is making is without anything on record, Your Lordship. He has not filed any affidavit in reply to my. He has not filed any affidavit in reply to my affidavit in opposition. So these are mere submissions.
Lordship, but that's part of the record. Part of the record, Lordship. Yeah. I'm not going beyond.
It's an admitted fact.
It's on record, Lordship. It's on record. My documents, their documents are on record.
Item 35. Heard Mr. N. Muzoi, learned counsel for the petitioner. Also heard Mr. V. Zimobi, learned senior government advocate representing, learned government advocate representing respondent number 1 to 4. Also heard Mr. T. Ponginer,
Respondent 5.
learned counsel for respondent number 5. Hearing concluded, judgment reserved.
Obliged.
This book I will require. Anything left? Nothing left.